Welcome to Looking at Legal Stuff. Today we have part 2 of this saga with 13 hearings covering 3 different cases, all with the same ex-boyfriend. Her ex has made 2 motions, one for a protection order and another to compel the return of his belongings, while the woman is suing to try and establish that she is owed money because they were in a committed intimate relationship, which is like a common law marriage. The woman has constant meltdowns in court and refuses to participate in the discovery process by repeatedly making false claims that she can't send them any information until she finds time to create spreadsheets for her auditor, despite no auditor being involved in the case. And besides, how is she supposed to find time when she has so many cases? What does the judge think of her crazy excuses? Let's find out. Don't miss part 1, which covers the first case in this saga where Mum is in court with her ex-husband. I'll link it for you down below. This video will switch between hearings for separate cases. I have labeled each hearing type at the top so you can follow along. Mr. Bopp has 2 cases before the court. The first is a protection order, but those are not streamed. I will share the details of that case with you at the end in screenshots. The second is called a writ of replevin, and this is the type of motion you file in civil court if you want to be able to return with the sheriff to collect personal belongings that the court decides are yours. You need a motion like this when the other party is refusing to cooperate. On the flip side, Mandy is suing her ex for money, claiming that they were in a CIR, a committed intimate relationship, and she also claims that he was her employer and is refusing to compensate her for services in remodeling the kitchen. You can check the label at the top if you're unsure whose motion it is.
All right, so I'm going to go to Bopp and Gronitz. Do we have everybody here on that? 23-2-53908.
And that matter's ready, Your Honor.
Can you hear me?
I can, thank you. This is Ms. Gronitz?
Yes, this is Miss Mandy Garnet.
Okay. First question, Ms. Gronitz, did you have any objection to what's being requested, just in general?
I have objections to everything. I have objections to the entire case. Did you receive my declaration response? Do you have that?
I do.
I submitted it.
Right, I have that. My question is what the request being made today is for the court to handle these 2 cases together as opposed to 2 separate cases, since they're interrelated. That's the only decision in front of me today.
Today is regarding let me pull it up real fast. Order for consolidation?
Correct.
That's today's? Okay. Yes, I object for the order of consolidation. The purpose of filing the committed intimate relationship is it's a family law issue. We're currently in civil law defending, they're separate cases, Your Honor, and they need to be deemed separate cases. As far as judicial efficiency goes, I have a degree in efficiency, and it would not be efficient to consolidate these cases because of the elements that have not yet been successfully submitted for your review regarding what they have submitted.
Ms. Winkles?
Yes, Your Honor. Actually, all areas of family law are under civil law. Family law is just a separator that comes between them, but everything that is a family law case is a civil law case. Committed intimate relationships are obviously judicial born. There's no legislation. We're talking about pure case law. These are black and white issues, especially when there are no children involved, as there are no children here. The purpose behind family law court is really because you have so many of these hearings and they have to get into details with guardian ad litems and parents and children. We don't have any of this. We have a purely financial case that also has the extra added on issue of whether or not there was a contract for the purposes of a remodel of a home. So we have 3 issues. The first one is replevin. Who has better possessory interest in the chattel and the items? The second one, was there a contract for the construction or renovation of a home? And if so, has that been breached? And number 3, is there a CIR? All of these 3 questions have to completely independent. You can't have one you can't have one and then the others have them as well. We have to figure out all these 3 together to figure out which is actually the issue in the case. And really the only place that that's going to happen is on the civil docket, because you have issues with contract and you have issues with whether or not there is the need for a replevin or conversion. Really, the only other minor issue that tends to go to the CIR, which is really a fact question, was there an intimate relationship? Everything else about the entire case would come under a civil law docket. It makes sense to not have three separate cases. It makes sense for the purpose of the parties to get this done once, to make the decisions, to have one judicial officer go, through the case until trial, and then to finish it. If I were to go for a replevin right now with a CIR, the question then becomes, my client does have better possessory interest, so he should get it all back, bearing the outcome of the CIR. But that doesn't make any sense. It seems that it all needs to go together. That's why we put it here. That's why we requested it. We're going to have three different judicial officers assigned. It doesn't make any sense. So we'd ask that it continue on the civil docket, that it be heard all together, that any future filings that have to do the same chattel, the same personal property, that all falls under this case. Thank you.
Well, it seems to me this is the case. You got to figure out the CII before you can do anything in the replevin case.
But there's also then, she made the claim that she had a contract for the construction of the house, which would negate a CIR claim. So really that one should come first, which is the reason I said it should go on the civil docket, because if there was a contract for renovation of a home and she's getting paid as a contractor, that means there's no quote unquote marital community in a way. So that's the problem.
That's just evidence of that. It doesn't prove anything. It's evidence towards the proof. So, I mean, it seems to, well, there's a couple of problems. First off, from a fundamental standpoint, I've talked with the clerk's office, and actually consolidating two different types of cases like this creates a whole bunch of technical problems within Odyssey. And so what she can do is relate two cases, so they're kind of tied together, but they're not actually the same case. I mean, it seems to me, again, I've reviewed through both of the basic pleadings, and we only have two cases, not three. And it seems this probably belongs on the family law docket to be dealt with under the committed infant relationship case.
Do we need to be filing the same pleadings in all the cases then? That was one of the reasons I tried to consolidate them.
Well, if you think they're appropriate for both cases, then you would.
Okay. My other issue is I don't know what's been filed by Ms. Gronitz because she's not serving me. So I don't know if there was a response that made it seem very, very family oriented. To me, it was a question of money. So I had real property, but I will take a look at that. So I guess I can always bring the motion to consolidate afterwards.
Yeah, it's fine. But my thought would be at this juncture, I'm talking with Stacy, would be to have the clerk's office relate these cases together so we don't lose track of them. So we're aware there's two cases that are kind of interrelated. And then again, like I said, my first reading through this, and I didn't spend hours reviewing both cases, but it seemed like the CIR kind of was the piece that needed to be addressed, and then the other pieces would fall into place. But
okay, we'll do that then. Thank you, Your Honor.
okay, so I'm not going to sign the order of consolidation, but I'll have the clerk relate the two cases so they're tied together in Odyssey, so we know there's two matters. Whoever's looking at one case will have access to both easily.
Perfect. That's all we want. Thank you, Your Honor.
Okay.
Gronitz and Bop, cause number 23-3-00344-08.
That matter's ready.
Right. I guess I'm just trying to, my question on this one maybe I'm missing something, because I know there's motion set this afternoon.
This is a very specific motion for partial summary judgment. There's been obviously a CIR claimed in the replevin. This is looking at just anything owned prior to 2018. Since it's a CIR, obviously not everything's on the table, only the things during the relationship. So this is, we might come to an agreement. I've been talking with, I'm not sure if she's in the courtroom. We're kind of working that out, but in the meantime, I just want to get it set It's looking at just the property prior to 2018 as they agree on the date of the date the relationship started. They don't agree on whether or not it was a CIR, but they do agree on the date.
Mandy is not present.
I was talking to her up until around 9 a.m. this morning. She did say that she wants, hold on, she wants a considerable amount of time before it's set.
Would probably need to be
Yeah.
in November just for timelines
If
at least.
she wants at least 2 weeks to get everything together before she can even answer, and I'm happy to do that because, like I said, it does seem like we're working on a settlement agreement on at least this issue. If we can put it out, normally it's 28 days. If we can just add 10 days onto that, I think that would be sufficient for her to get an answer unless we settle.
So I'm thinking, just looking at my calendar, it's probably the week of the 5th of November that we have something available.
I'm in trial, but I think I could probably, are we doing these on Mondays, Fridays? Is it just open? I don't mind doing the trial and this in the same week if I have to.
This is a 2-hour set.
Yes. And I doubt it'll take that long. Again, it's just a very small issue. It's just to focus on just a certain time period.
It can be set anywhere between a Monday, Thursday, Friday, and a Tuesday, Wednesday if we don't have trials set on those days.
And that's fine. I think I can handle both.
I mean, the alternative is if it's not over half an hour, if you don't expect that can just go onto a regular family law docket as well.
Unfortunately, I think my argument would be probably around 20 minutes, but given that we've had a number of motions that seem to go way longer than they should, I think it would be better for Ms. Gronitz to have a little bit more time to argue. And so I think probably 2 hours would be reasonable.
So are we looking at week of November 6th?
And that works for me.
Okay, that Friday is a holiday, but I can do a 2-hour set week of November 6th.
Okay. That works. And that's at least 28 days from now. Correct?
Well, it's 28 days from filing, at least.
Yeah, I just want to give her a little bit more time. I think that'll be fine though. And I can speak to her as well. If we have a problem, we can come back.
Okay, very good.
All right, readiness will be October 31st at 11:30.
All right, that works for me. Thank you.
Thank you.
Let me just 1 second. I want to make sure I think I'm down to the Bopp and Gronitz matters. We handled everything else, did we not?
We did, Your Honor.
Okay, great. I just want to make sure I didn't move things around the screen here. So I see we have Ms. Gronitz, we have Ms. Winkle, excuse me. So this is on for a couple of motions. One is a motion for advance fees. One is a motion to compel.
And there's also a motion for sanctions for a deposition.
Correct.
Which one do you want to take first,
I'm
Your Honor?
gonna take the fee one first, since that I believe was the one that was filed first in time. So Ms. Gronitz, if you want to anything you'd like to say about your motion for advance fees?
I extended the date on that till next week. I have it inaccurately represented as lawyer fees. It should be production costs for discovery. So I have to amend some paperwork for that. So that's not ready for today.
So you're
Is it not
striking-
here that I put in a docket notice change?
hold on a second here. Oh, I do. There is one for the 18th of October. Looks like that's what that one is.
I anticipated this case getting set over, so I set that date in advance to secure a slot.
I have not been served with that. Is that on its way in the mail, maybe?
I believe it was sent email the same day it got submitted to the court. I'll double check that and I can resend it.
Okay, that'd be great. Thank you.
Yeah, it looks like it was filed on the 6th.
Okay, it might just have been lost. We've had a
Yeah.
lot of emails.
Just an amended docket notice, so,
Oh, I can look that up. No need to reserve.
okay. So I will, I don't see any amended motion. I just see an amended docket notice. So. Okay, so moving to the motion to compel and the motion for deposition costs.
And Your
Yeah,
Honor,
sure.
I'm sorry to interrupt. Would you mind just muting the iPad? I'm just getting some feedback.
Sorry?
I'm just getting some feedback on that iPad. Will you mute it?
The iPad one, let me see.
Yeah.
A second here.
I'm sorry, Ms. Winkles.
Oh, you're fine.
I'm gonna remove both of those. It looks like those are both still, everybody in them.
Thank you.
We get some feedback. So there we go. That'll help things. I see a Kalisha Baker trying to log in. Is that somebody involved in this case?
Not on our side, Your Honor.
It's not a familiar name for the matters. All right, go ahead.
Yes, Your Honor. I hate to come to the court with this because it's a problem and it's costing my client a lot of money. And the delays are, it's extremely problematic. So I'll start with the motion to compel. Normally I would bring on these motions and I'd feel absolutely no regard for either side, and I would just bring them and we try to get the discovery. In this case, I'm very concerned with some of the responses and some of the actions, trying to, how to put this. And I'm concerned that I'm going to essentially be wasting my client's money and attempting to get these orders, and it's just going to be this procedure over and over again, but I'll never actually get them. So I just wanted to state that to the court. So the discovery we submitted to, we just served on the defendant on August 8th. We had a CR26I, and I asked her how much time did she need. She said 2 weeks. That was fine. I would have given her longer if she'd asked. It went by and we've received nothing. That was September 25th. I normally would do another CR26I with the pro se person just because they're not aware of the rules. However, I've received emails stating I'm not giving you the discovery. I'm not doing this. And that's my concern, is that my client is now in 3 different cases with the defendant. And it's getting to be the most expensive case I've ever had in this short period of time. It can't go on. It's going to bankrupt my client and the stuff that he's trying to get back and she's trying to get. It's never going to come out to how much the legal fees are. I ask Your Honor to compel her and to do an order of attorney fees, but frankly, I think she's judgment proof anyway, and I'm not sure it will serve a purpose. However, maybe I guess if we go down the sanctions route and keep coming back, but it's just so expensive for everybody. And my concern is that things keep getting more erratic. But in any event, we've done everything we should do. The discovery is long because it obviously has some elements of the relationship in there and her affirmative defenses. I was happy to give her extra time, but we're now at October 11th and we've not received anything concerning. I can't even justify a settlement without knowing what the basis is for her affirmative defenses. If we go into the deposition, we scheduled a deposition. We sent a notice of deposition. We gave plenty of time for her to respond. I assumed she was going to be there. The court reporter was there. I was there. Mr. Bob was there. 20 minutes beforehand, she called and canceled and said she was in Seaside and her car was broken down. Normally, if your car is broken down, I wouldn't have a problem and we'd, talk about the money for the court reporter. However, the problem is why you would be in Seaside and only give notice 20 minutes beforehand. If your car is broken, you would have had to have left Seaside an hour and a half, 2 hours before. That's when you could have called or you could have emailed. I work at 6 a.m. every morning, even the night before. We could have tried to figure out some Zoom or something like that. In any event, again, it's just cost my client money. So every email, and there's hundreds of them, but with no discovery, every time I come to court, every time we submit a declaration, every time we respond to a frivolous motion, it's just costing money. And frankly, it's not worth it for my client. And I feel bad doing it. Unfortunately, I'm also sitting here and I've got to pay my staff, but I'm not sure what to do at this point. I'll ask for sanctions. I guess I'll ask for the interrogatories to be attorney fees, and I'll ask for the deposition to be, I guess, additional attorney fees with some stricter sanction other than attorney fees, which might get this rolling. I'm more than happy. The argument is I haven't submitted mine to her, and she hasn't followed the procedure, but given that she's pro se, I will submit that. But I'd like to actually receive something to make this end, because I'm going to be in front of Your Honor probably every week at this point, and my client just can't do it. And at this point, normally I don't argue like this. I just go after them and like a bulldog, but I want to be compassionate here and try to find some sort of resolution. And I'm hoping that the court will assist us today in coming up with a way to move these 3 cases forward. They're all intertwined, and we're going to be here on another motion to compel and another motion to compel a deposition in 2 weeks' time. And it's just too expensive. Thank you.
So, just so I understand the status right now, you've currently got a deposition scheduled for day after tomorrow.
We actually canceled that because I got an email about 2 days ago that said I'm absolutely not coming, and in which case I'm not going to pay the court reporter to drive down from wherever she comes. I don't think she lives in this area.
Okay, that answers that question. Thank you. Ms. Konitz, any comments or response you have?
Yes, Your Honor, I would like to start with the identification that I have vacated Cowlitz County as of May, and any requests for personal appearance are absolutely unnecessary, because any information that needs communicated can be done via electronically. Where I stand on this case specifically, this is the Replevin case, right? Sanctions for lack of discovery, is that correct?
There's 2 motions. One to compel the interrogatory answers. The second one is some sanctions for not showing up at the deposition. Those are the 2 things that are really important.
Both are discovery related, correct?
Correct.
Okay. As counsel suggested, I am pro se. I am not an attorney. I'm an accountant, a business systems analyst. So I operate with true, accurate numbers and data. I am in 3 court cases, all of which have conflicting information brought forth by opposing counsel. We are really close to having this done. In fact, today you actually have permission to dismiss this case, because I have found alternate remedy for every problem that opposing counsel has brought forth. Let's just review. What did she just say? Lawyer fees, that's amended till next week. Compel and responses. I would like to bring light that the only reason I missed the discovery meeting was my car overheated. It was broke down in Rainier. I was without a phone in a car for 3 days. I had to have a friend go pick that car up, and then another friend go pick it up on the 22nd. I had to find a different friend with a phone. I exerted extreme effort to make discovery, or at least to contact opposing counsel about discovery. I do admit that I missed it, and I was late, so the $75 fee appropriately could be assigned to me, because it wasn't a forecasted intentional miss, but I did miss it. As far as discovery goes, we have 2 different cases. This specific case is about theft of items from a, what does she call me? Oh, short duration relationship who waited till I was moved out of the house, broke in, and stole a bunch of stuff. Okay, that's the position of opposing party on this specific case. They're claiming I stole.
Ma'am, let me
to return those.
Let me stop you for just a second. So I'm not looking at the details of the underlying case today. What I'm looking at today is a request to have you file the written deposition or written interrogatory answers. That's one issue. And the second is whether or not I impose some sort of sanctions, whether it's fees and costs on this missed deposition. Those are really the two issues that I need to focus on. And I'll have some more questions once I hear your position on those two things. But I don't need to hear about all the underlying case. I understand what the cases are about because I've dealt with them at some level up to this point. But what we're here today about is purely the interrogatory answers and the not showing up for the deposition. Those are the two things I need to have you focus on.
The not showing up to the deposition was unintentional due to my car breaking down. I did make extensive effort to notify opposing counsel as soon as I could about it. Interrogatories. I've been hit with 400 pages of information. I would like to counter propose to opposing party a streamlined solution. I have 50,000 records to go through and create a spreadsheet to recalculate 5 years of a committed intimate relationship, both of my contribution. It is only to my benefit to provide discovery. So the idea that I am opposing providing discovery counteracts my entire argument that my entire case is based off of the discovery I can provide. So I am extremely motivated to provide this discovery. However, I've had 20 court cases in 21 weeks amongst 1,500 different paperwork things. I'm in 4 different dockets, 5 different cases, 200 line items into this case. So I would like the chance and the break to actually provide the discovery, which is going to take me 60 to 80 hours to compile, compute, and generate. I can provide the opposing party a spreadsheet to match my spreadsheet. So when we come to court, all the court has to do is match comparable spreadsheets of contributions into the relationship in the CIR, and we can divide assets per ratio of contribution effort. I just needed time to make the spreadsheet. We have a readiness hearing October 31st. I can provide my information by then, as long as I'm not distracted with the 400 pages of information I got last week. This entire case today is procrastinating me from accomplishing the goal. Every single motion on this case has been a distraction from me accomplishing the goal. Because 60 to 80 hours in June, I could have had this done, but I've been in court every week on other things, but getting discovery submitted. So this case sits where it lacks evidence to even make the claim. It's the wrong venue because the assets are either being disputed in the protection order, which I just negotiated a agreement between parties to exchange personal property from the relationship. So we can finally, after 6 months of it being in a holding pattern, exchange property. I don't want his stuff any more than he wants my stuff. We're trying to give it back and forth, but the protection order blocked access for me getting rid of his stuff and him returning my stuff. But I satisfied that Monday with Judge Carmi. The rest of it is a vehicle, some trailers, and things that are in the will. And a will is a contract by law. So that's disputed in the committed intimate relationship. This case, Your Honor, from an accountant perspective, I'm looking at the numbers. What I read on their submittal is that the assets that they are contesting equate to $27,000. Of those assets, I could rightfully contest committed intimate relationship $10,000. I would only get half of that. That's $5,000. This case is $5,000 worth of property value. Her bill is $25,000. I don't understand how she warrants a $25,000 attorney bill to fight for $5,000 worth of stuff when all I had to do was ask the judge in the protection order docket to allow us the chance to exchange it via third party person, which I asked him to do in May. He could have resolved this in May, just allowing us to move our stuff without this entire litigation process. Every part of this process has been his own expense, of his own choice, simply because he didn't want to be cooperative in May. So I would like to give him his stuff back. I would like the chance to submit my discovery without them harassing me via the court system with all this additional paperwork that is completely unnecessary. Thank you.
Ms. Winkles.
Yes, Your Honor. We don't have a settlement. It's always hopeful. The cost is, and I've written off quite a lot of my bill. We just can't go on like this. We've done everything right. I've tried to be friendlier than I've ever been in any case. I am concerned here. I've asked for the discovery. I keep getting pushed off for everything. You'll get, I'll gladly give you a hand, it's like, just wait till Tuesday, or I'll have it on Tuesday, and Tuesday comes and it never happens. There has to be some sort of, she has to be held to the same standard as a lawyer. That's what the law states. And is it fair? Well, I have my own thoughts on that, but the fact is that's the law. And I've tried to be really, really malleable here and allow more time. But the fact is we need this to move forward. My client can't continue. It's more than $27,000 worth of stuff. Literally, the knobs to heaters were taken. I mean, like one sock from every sock type of pair. That's the type of stuff that was taken, but it was everything, minus her stuff. And so we sit at a place where we can't move forward, but we're going to keep coming on motions. Motion for attorney's fees, which is now turning into, because that was denied in the protection order, a similar one. Now it's turning into a motion to produce documents. This is what's going to keep happening, and it's going to bankrupt my client. And I think it's going to make Ms. Gronitz more erratic. Right? It's not going to help anyone. So I would ask that we follow the letter of the law here, that Your Honor compels her to produce them. That's fine. Give her 2 weeks, give her 3 weeks, but does some sort of sanction so we can be sure that we're not going to be back here. Again, I highly doubt an award of attorney fees. As much as she does own personal property, or she does own real property, I can attach a judgment to her real property, and maybe in 30 years time my client can get paid back. That's fine. I don't think it's going to work. But I'm willing to go through any step. The deposition as well. We're asking that, because of the October 12th being canceled as well, we might be able to resolve this on a summary judgment as the story keeps waffling and changing, if the person that's giving the story is held to penalty under perjury. And I'd ask that Your Honor compel her to be at a date certain for a deposition. I will clear my schedule that date. I'll make it happen as long as it's not a trial. And that she be sanctioned, even if it's just $75, but we move forward in the level of sanctions as it is indicated in the court rules.
I apologize. I've got a bit of a.
I'm losing my voice, so I understand completely.
So a couple of questions. First off, you're still wanting to do a deposition. Is that my understanding?
I do, and I'm wondering if I can get some of these. My concern is that I'm not going to get some of the more technical questions. How much are you saying you're owed? Some of the technical things, I think I'm going to need the production of documents. But some of the other questions we can probably satisfy. Just when did you start a relationship? When did this happen? We can probably satisfy that in a deposition. So the deposition, I would say, would come first. The production of documents is important because it's obviously the claim for the liquidated amount, the ascertainable amount, but they both need to come. But I don't need to ask for interrogatories necessarily. I can do that in the deposition. It would just be a request for production at that point.
So, Ms. Gronitz, you indicated you're no longer in Cowlitz County. Is that what I heard you say? You're muted. I can't hear you.
And just so you're aware, Your Honor, we'll do Zoom. We can do a Zoom deposition, no problem.
Ms. Grunitz, can you hear me?
I apologize, Your Honor. I lost connectivity there for a few minutes, so I've been out of the meeting for since Ms. Winkles began. I vacated Cowlitz County, and so Mother's Day things got contextual. The same day, my parents got offer for property, the sale of their property. So I helped I'm in lieu of helping my family move, rebuild. I got 3 different house construction projects in Lewis County. Then this month I have scheduled some travel arrangements. I've exhausted Cowlitz County, Clark County, and Lewis County legal sources. I'm seeking all resources across the state.
Well, my question
I'm gonna
is,
visit some friends who know a lot more about this than I do and are willing to help me.
okay, we've got a really
Is
bad,
there a reason we can't just exchange spreadsheets, Your Honor?
well,
My service is
let me finish, ma'am. So let me a couple more questions. So are you unwilling to do a deposition? Is that was somehow
I
really,
believe a deposition provides very little information for the time and energy exerted. Plus, you mentioned on one of her papers it's $3,500. I just need some time left alone to spreadsheet. So no, I don't want to do a deposition because all that does is distract me from actually accomplishing the goal. All I need to do is go back and calculate the time and costs exerted into the property of the relationship. 60 to 80 hours. So after 80 hours, if I have not computed a spreadsheet with information, then she can go off. But I've been in court every week. I've not had a chance to just sit and compute the information. I've collected it all. It's waiting for me to data entry and push off. I have to data entry, format. It'd be nice for him to have the same spreadsheet so it's side-by-side comparables because I do accounting, and when you're working with comparable numbers side by side, it's easy to make a decision. So that would be nice for them to provide their discovery. They have not provided a single ounce of discovery to me while they're trying to file sanctions that I'm defiant against them. They should provide me the same thing they're asking me before we meet again or before they ask for a deposition. They haven't offered his deposition. What does a deposition offer? This is just about the numbers, and the numbers mean I need time to get the information on a spreadsheet so that you can review it. Anything else is a distraction from the goal. The goal is, what did he contribute? What did I contribute? Anything else is a distraction. So no, the deposition is unnecessary until we get the spreadsheets with evidence to support the claims. It's a waste. I'm sorry. I just don't understand the value it offers. So it's not a defiant maneuver. It's the lack of understanding why it takes over the true goal.
all right, so, Ms.
But then
Grunitz,
again, I don't get paid to litigate. I get paid to problem solve.
okay, so one question for Ms. Winkles. How many pages discovery is this? I mean, it was indicated as 400 pages.
Oh, no, it's nowhere near that. I also, just so your honor's aware, I knew that she was pro se, so I left plenty of room for her to write. The questions were far spaced. I can tell you in 2 seconds how long it was. I usually put 3 questions on the page.
Pages, 300 questions.
Yeah, so it'll be 60 pages with 2 to 3 questions on each page. So it'll be about 120 to 180 questions. Some of the questions are, what's your name? Who helped you do
pages of
things?
discovery.
Well,
It's over 300 questions.
I don't do compound questions. So to pro se people. So one question will be, when did you meet? And then the next question, how did you meet? And then, were you ever engaged? did he ever buy you a wedding ring? What did you take from the house?
Yeah, I understand.
Yeah.
It just seems like an unbelievable amount of discovery, but
If you saw it, it's not. It's just I've been objected to because of compound questions. So now I just piece them out. It just seems like
Okay.
it works better.
okay. So Ms. Gronitz, here's where you're at. It's not your decision as to whether a particular form of discovery is good, bad, or useful. If either side wishes to do that and they follow the court rules to do that, they can do that, and you have to cooperate. So you can do those via Zoom. You can also do them in person.
Zoom's fine. I can do Zoom, Your Honor.
Okay, the
We're
problem.
doing Zoom right now, right?
Well, just listen, can you maybe listen to me for a second? Part of the problem with Zoom is the problem we're having right now. Your connection is really dicey. You're kind of breaking up now and again. So that's a potential problem with a Zoom deposition. If you've got real good internet, then that usually works pretty well. So that's a possibility. It sounds like that's agreeable to do that, but I need to have you tell me you're going to cooperate and do one of those if they request it.
I can also go to Lewis County, Your Honor. I used to work there, and I'm sure my old firm would allow me to use a room if that would be easier for her.
So, I mean, you guys can work that out how you want to do that. But if they want to do a deposition, they can do a deposition. There's all kinds of reasons that those are done. Sometimes, and it sounds like this may be a case like that, some of the discovery questions that you're working through could be dealt with in that fashion as opposed to having to put it all in discovery. So I guess a couple of concerns I have. We set a summary judgment motion in this case. And I forget the date we set that. I don't have it in front of me here.
I believe it's November 5th. I did the week of, I did already email Ms. Gronitz and tell her that as soon as I got the scheduling order, I'd send it to her. That's a very small question. I mean, it's just a question of anything before they met.
Okay, so that'll be a separate issue, and some of that may be even agreeable, but that being the case, first off, when these things are set up and people, coordinate things and they get the reporter lined up and there are expenses involved in doing that. I understand your issue on this particular one. It's a bit concerning that it was so late canceled. That very well may be appropriate given what you described as what happened. And then I guess it concerns me that there was some email that may or may not have happened where you said you weren't going to do a deposition, but it sounds like we're past that. So you're agreeable to do one as long as it's in Lewis County or via Zoom. Is that what I'm hearing?
Via Zoom. And it's never been an opposition of doing it. It's been an opposition of understanding the value versus getting our spreadsheets matched first. I just want to get my information together first. I can't give a deposition without having information collected and processed. So I need
I understand.
8 hours before they even consider to do the deposition and before they hit me with another package of 400 pages. I need time. We have October 1st. I didn't have my information to them by then without a deposition. And then after that, if what I provide isn't satisfactory, then we can do a deposition. But the provisions governing discovery do not allow. We're supposed to make a schedule that works for both parties, and they have not done that. They're trying to. Their purpose for requesting discovery, I don't believe is honorable, Your Honor. I have to get my information together first. It's just how it is mathematically. I need to know what I'm depositing about before I can ask questions. I don't have the information filed. So I can't give them the information until I get it ready. That's all it's about.
Okay, well, are you currently working, ma'am?
I am working 100% pro se, 5 lawsuit cases in 4 different dockets for free. No, I have not worked since May 15th when plaintiff refused my wage claim.
Okay, well, I don't have the interrogatories in front of me, so I can't make a really independent assessment as to how much time is involved there. Again, I don't know what, I don't have any of that information in front of me, so.
And Your Honor, if she does the deposition, the interrogatories can go away. I would just need the request for production. I believe there's 21 of those. If she does the deposition, I just ask her the questions. Because they, they're just normal questions about the relationship and things like that. The request for production, 3 weeks is, she's had since August, but I don't mind waiting 3 more weeks as long as I can depose her on the other things so we can, move on.
So you need those documents before the deposition, correct?
No, the deposition is about the CIR. That's just facts of
Okay.
them. Sorry, my cat's meowing. That's just the facts of their relationship. The documents that support that, she can have, she'll come in for the deposition, then we can have the request for production 3 weeks from now, deposition next week. We'd be done. And then she can supplement her spreadsheet. I don't mind that. What she's using to generate that spreadsheet is what, just give me a copy. You don't even have to give me a copy, come to the office and I'll make the copy. Anything like that, or tell me where I can subpoena to get the copy.
Okay. All right, so Ms. Granitz, here's where we're at. They want to do a deposition, they're entitled to do a deposition, so I'm going to require that you do that. What I am going to do and there's a whole number of parts to this decision, so I want you to listen carefully. One of the things I'm going to do is to make sure things are following through, is I'm going to put this on for review next Wednesday. That'll be in front of Commissioner Carmi, who sounds like she's somewhat familiar with your case. And that's to make sure that we've got a deposition set up or completed, or so to make sure that that's all understood and everybody's on the same page and we're moving that forward. As far as the interrogatories, or the request for production, let's focus on that. When did we schedule the summary judgment?
I believe it's November 5th.
November 5th. Okay, so if we required all those documents to be turned over maybe by the, you said November 5th? A week.
Oh,
up.
it's November 6th. Mr. Bob held up his hand. It's the 6th. Sorry, it's that Monday.
Okay. Yeah, I was looking at the calendar. That wasn't working right. So here's my thought, is that the request for production part of that interrogatories package that you got, I'm going to order that you have all of those documents, copies of those, provided no later than noon on the 25th. No, excuse me. Yeah, noon on the 1st. That's 3 weeks out from today. If you have a challenge on getting a particular document, you need to indicate in writing where that can be found or why it can't be found. And what we're going to do on the 1st at 2 o'clock, that'll be again Commissioner Carmi at this point, make sure that those have been received by Ms. Winkle's office. And if they haven't been resolved, I mean, there's 2 dates. There's one next week on the 18th and one in 3 weeks on the 1st. On the 18th, Ms. Winkles, if you want to strike that, if you've got everything in order for the deposition, I'm happy to do that. Just let us know. Okay. Really the same on the 1st. If everything is in order, we don't need to have that. That can be stricken.
Okay.
But Ms. Granitz, I'm requiring that you appear for those two hearings, one on the 18th, one on the 1st at 2:00, so that we kind of see where we're at on this thing and make sure you're following through.
And Your Honor, my only question is, can we have a drop dead date to schedule the debt? So I guess, if she called me tomorrow and said I can do it in 2025, that's going to be a problem. Can we have a date where we have to schedule it somehow before then? And I'd even do it on a weekend. I don't know if the court reporters will do it, but I'm really flexible here for her.
You need it before the summary judgment.
No, because that's really questions of when their relationship began. As long as she's willing to answer that, I think we're in agreement anyway from some of her pleadings. But I would like it before, definitely before the 1st.
So if we,
I guess I can do it for the 1st. I mean, if we could do before November 1st, that would be wonderful.
that seems reasonable to me, and that's what we'll take a look at next Wednesday to make sure we've got it scheduled, everybody's in agreement. And you can, so did you get all those dates, ma'am?
Yes, Your Honor. May I request the opposing party provide their interrogatories as well, so we have balanced packages to look at, because they have not provided me any discovery while they're motioning for sanctions for my lack of discovery.
And
So I would like
absolutely,
discovery at the same time as well, please.
I will provide that to her before the 18th.
Okay, so that's before next Wednesday, you'll have that.
Yeah. And I have it done. I'm just waiting on a few documents, but I'll let her know which documents I'm waiting on, so she knows how long it'll take.
Okay. So you've got basically 3 weeks to get all of the documents that you've been requested to provide. You're going to have to participate in the deposition sometime before the end of the month, basically. So you got about 3 weeks. So you work with Ms. Winkles to get that scheduled. And then we're going to review it next Wednesday on the 18th and 3 weeks on the 1st to make sure everything's going the way it's supposed to go. And I'm gonna give you a gigantic carrot, ma'am, and that is I'm not going to impose anything other than, as of today, I'm going to impose the cost for the reporter. If you don't follow through on these two requests, when you come back on the 1st, I think there's a request for about $6,000 or something like that, and whatever that number is, I'm going to award that amount of money. So that'll be either paid by you or come out of whatever ultimate settlement there is. I'm not going to order that today. So I'm going to give you an opportunity. I'm not saying I'm not going to order it at all, because there may be some fees that are adjusted as this thing moves forward. But what I'm telling you is, if you do all the stuff you're supposed to do, I'm not going to order that immediately. I'm not going to promise it won't get ordered, but I'm not going to do it by that date. Does that make sense?
What I hear you say is, if I appropriately get my financial report showing my last 5 years of intimate committed relationship and or wage contribution investment in, it will save me $6,000 in fees. So I am motivated to get my report in aside from the fees, and that just adds to my motivation. I will get my report in, Your Honor. And it will incorporate the elements of the interrogatories that may match the format.
And Your Honor, again, just so I can stress, only those questions that say request for production, she needs to answer, because anything that says interrogatory, she doesn't need to answer, because I'll ask her that in over Zoom. It's just the ones that say request for production, and there's very few of those. That's all I need from her in written format.
So let's do this. You have those, I assume, in a document that could be.
I will email it to her.
You could email just the questions specifically
Absolutely.
that she needs to answer, so there's no question.
Mm-hmm.
So Ms. Granitz, you're going to receive an email that has the specific questions that you have to comply with before we come back on the 1st. But I don't want you to spend any time on the other questions, just the ones that you have to get answered, so we can keep your case moving forward, okay?
Thank you.
All right.
I appreciate that, Your Honor.
I didn't catch that, but that's probably okay.
I just said thank you.
Oh,
I
welcome.
will answer those specific questions before anything else.
Work
Okay.
on those, and then you got to participate in the deposition, work with Ms. Winkles, because we're gonna come back next Wednesday. If it isn't scheduled, then I'll instruct Commissioner Carmi to simply schedule it, and you'll be expected to show up. So,
Can we schedule that now? I'm looking
Yeah.
at my calendar. I have court on the 31st. Is there a chance to schedule it sometime after that? I have documents. I have 4 different cases in 4 different dockets. And I have a huge trial coming up on the 31st. And I think this ties with that. So if I can do this after that time, if I don't have everything else satisfied by then, because I'm looking at closing this case
Okay.
by then.
hold on just a
So
second.
the whole
I'm gonna-
every request will be unnecessary.
All right, Ms. Granitz, the connection is not real good, so I'm gonna have you and Ms. Winkles schedule that by phone call offline, just so we don't get any misunderstandings.
And
Okay,
if she,
Yes.
and just so she's aware, if she wants to do November 2nd, because it sounds like she has a trial on the 31st in a different case. I'm fine with that. I would just need from, let's say 9 a.m. to noon, and that's it. And I can give her the link and we can do it by Zoom, and if connection's bad, I'll
Agreed.
direct her.
all right, so
And she can call
I'm
back.
gonna have you guys schedule that.
Okay. All right,
We'll
thank
come
you.
back Next Wednesday, we'll review it. I'll talk with Commissioner Carmi so she's up to speed on what we're doing.
And I will prepare an order for your honor.
Perfect. Thank you.
Okay. Thank you.
You're welcome. Have a good afternoon.
You too.
There was a review hearing on October 18th and another on November 1st that I don't have copies of, but Odyssey says that Commissioner Carmi ruled on the deposition date and she reserved on attorney's fees. She also struck a motion by Mandy, who was trying to get advanced lawyer fees and costs.
Okay, let's go to the Groundnuts and Bop matter. I have 232-0053-908. Ms. Groundnuts is with us. Ms. Winkles is present representing Mr. Bop. I have this both on a motion to compel and a review hearing on attorney fees. Let me jump into the digital file quickly.
And I'm sorry if you can hear my dog snoring behind me. He's very old and it's very loud.
I can't hear it, but
Oh, good. It's very loud. I was concerned. He's 15, so he's a loud old man.
okay. So when we were together last, there was a deposition that was going to take place the next day on 11/2. So I reserved ruling on attorney fees to see if Ms. Groundnuts appeared for the deposition. So we set that on for today. I said I would consider a motion for partial attorney fees, even if Ms. Groundnuts did appear for the deposition, based on the amount of time it took to get her to a deposition. So let's start with that issue. What happened with a deposition occurring?
The deposition went through.
Okay.
Quite happy about that. That was absolutely fine. Concerning the motion to compel, based on the interrogatories and request for production, we kicked out the interrogatories completely, and we only requested the request for production that was under Judge Basher. We've now been requesting the same things on, I believe this is the third one we've been in front of, Your Honor twice and Judge Basher once, or Judge Basher twice and you twice. We still have only received bank statements. We've received nothing else. On the deposition, quite happy about it. But the fact is that she has a duty to respond to the request for admissions. We cut down our questions significantly. We tried to make every accommodation. We've had, and this is just in the Replevin, obviously the CIR is something completely different, and we have a CR 26I going on in that. But the fact is I don't have everything I requested. I don't even have a third. I don't even have maybe an eighth. I probably have an eighth of what I requested. I don't necessarily want the attorney fees. I would ask that we've already done attorney fees. I would ask that at this point, if she doesn't get them to me within the next 10 days, that you strike her pleadings. Because this is a case that is paperwork intensive. It's necessary to put on a defense. It's cost my client probably more than the property's worth at this point. she has turned over to my client about half of the property, not the vehicle and things like that. But it doesn't matter because we need the discovery. And so rather than attorney fees, since we've already done that and it doesn't seem to be doing the job, I'd ask that her pleadings, she have 10 days to materially answer the request for production and deliver them to my office. And if she doesn't, that Your Honor will strike her pleadings. And hopefully that will get us the documents we want.
Ms. Groundnitz, I'm going to come to you in just a second. I'm just reading from Judge Basher's, I believe, October order, where he heard this issue initially. He did specifically order that if documents were not submitted by October 25th, 2023 at noon, the pleadings would be stricken.
That's correct.
So essentially what's being offered at this point is an additional 10 days before that remedy kicks in. Ms. Winkles, what documents are still outstanding? Or I think you said some had been responded to. Is that correct?
Everything but the bank statements. So there were, I believe, 30 different documents we are seeking, 30 groups of documents. Only one of them was the bank statements. So we are missing 95, 97% of the rest of the documents.
All right, Ms. Groundnitz, let me turn it over to you. Let's focus right now our discussion on the documents that you need to get to Ms. Winkles that Judge Basher already ordered you to get to Ms. Winkles. What can you tell me?
That was my intent with the first notice of unavailability. I gave myself adequate time to provide discovery. Counsel has brought forth 10 hearings, which equates to 20 hours apiece for me. And mathematically, if I need 80 hours to provide discovery, she's brought forth 10 hearings. That's 200 hours that just got in my way of providing the discovery, hence the second notice of unavailability to block out further hearings, preventing me from getting this discovery in. I'm quite anxious and excited to provide this discovery, but I can't provide discovery every time I get issued another hearing. So the discovery is in wait. It's just waiting to be labeled. I have 200 pages of interrogatory requests on two cases. So obviously today is an example of going from a family law matter to a civil suit. The civil suit was inappropriately filed, and I would ask the court to assist counsel in narrowing down her ability to focus on one task at a time, which is the CIR, the only appropriate course.
Okay, so Ms. Groundnitz, what I'm going to do right now is assist you in focusing on the issue at hand on this docket. We had to do that on the last docket. What I am asking—
The last docket takes priority,
Ms. Groundnitz,
and I am getting those into her, and I promised her those by Friday.
Ms. Groundnitz, I'm going to ask you some very specific questions. They should just be short and sweet answers, okay? So as it pertains to this issue, can you get those documents to Ms. Winkles within 10 days?
I notified Winkles I would be delivering a package for the CIR, which has the exact same questions as this, by Friday. And I actually promised him, I started last Monday, but every time, yes.
Okay.
The interrogatories for the CIR will be brought forth, and this case needs to be dismissed.
Okay. So my question, it sounds like your answer is yes. I want to confirm you do believe that you can get the documents to Ms. Winkles within 10 days from today.
If I have no further delays from the opposition, yes.
Okay, I'm going to take that as a yes. So I am going to issue, Ms. Winkles, if you want to draft an order similar to the October order, indicating that Ms. Winkles has 10 days from November 15th to serve the answers to all interrogatories and requests for production.
Ms. Groundnitz.
Groundnitz, thank you. And
the reduced list.
Hold on. And that this is a extension of the court's prior October 19, 2023 order. And that failure to do so will result in the court striking the pleadings of Ms. Groundnitz in this matter.
Which pleadings? what pleadings are we discussing? I haven't pled anything on this case.
All of your documents. Okay, so it is
For the writ of
very,
requisition?
it is very, very important, ma'am, that you file your responses to Ms. Winkles. This is your second chance. The Judge Basher already ordered this remedy, but I'm giving you 10 additional days because Ms. Winkles and her client are offering that. Okay? And then Ms. Winkles, are you then wanting to hold over your request for attorney fees at this time, or are you moving forward on that today?
No, I'd like to hold over until again, I want the discovery more than we want the money at this point.
Okay, so then let's set you for November 29th, which would be a 14-day review of how this went. Ms. Grounded, can you be back on this docket November 29th? 2 o'clock.
Likely.
Okay.
Let me check. Yes.
Okay. And then we'll go ahead on the attorney fee review. We will continue that to November 29th.
Thank you, Your Honor.
I missed the time.
2 o'clock.
1 o'clock.
2 o'clock. 2.
2 o'clock. May I request that council stop issuing subpoenas and quit monitoring stalking me via process server so that I can have a moment to relief? My property's been surveyed. I'm being stalked, and it's not helping the discovery process.
I'm denying that request. If you have a motion with evidence that you want to bring forward, please do so. Okay.
I will do that. Thank you.
Thank you.
Thank you, Your Honor.
Thank you. You all are free to log out.
All right, so we're hearing the matter of Mandy Gronitz and Nathan Bob, cause number 23-34408. It's scheduled today for a motion for summary judgment. I noted from the clerk, she indicated that Mr. Bob and Ms. Gronitz are also scheduled for 9 a.m. on the protection order docket. So
They are.
maybe we could just touch base first on that. So I'm assuming Ms. Gronitz would like to be present. So would it be wise to pause and maybe just get an idea where they're at as far as their dockets before we proceed, or any thoughts you may have?
Well, I'm going last on that docket. So I've already explained to Commissioner Carmi that I'm on this docket as well.
Okay.
Let her know that if we could go last on that docket, and she said that was fine. I'm not sure if Miss Gronitz, I don't see her. Maybe unless she's in the courtroom, she's not on the Zoom for that, because I'm on both.
Right, and I'll double check with the court clerk. I poked my head into the courtroom too, where it's scheduled and it's noted to be today. I didn't see anybody in the courtroom, so I'll double check with Madam Clerk. Do you see anybody in the courtroom 2?
There's no one in courtroom 2, but people are allowed to go into the courtroom in the protection order docket, so she may be in that courtroom.
Okay.
I don't, I mean, there are about 10 people in there. I don't see her amongst the people. I do know she's returned about half of the items, so I doubt she'll be here today. It's just the remaining half that she hasn't. And she hasn't put in anything into the court file.
Right.
So I would doubt she'll show up for this part because it's a very specific partial summary judgment. It's only on items purchased before 2018 that we're talking about.
Right. So Ms. Winkles, you indicated that you're looking at courtroom or the protection order docket right now. You're looking at a list of individuals.
Yes.
And
I'm looking at it.
do you see her name listed as one of the Zoom participants?
She is not listed, and I don't see her in the courtroom either.
Okay, so you have a visual on the actual courtroom.
Yes, I do. I have a visual in the courtroom as well.
And do you know which courtroom that is?
Courtroom 1.
Courtroom number 1. I think what I may do, I may ask one of my assistants to just make an announcement in courtroom 1 for Mandy. How do you pronounce the last name?
Gronitz.
Gronitz. Okay. So Mandy Gronitz, I'll ask if she's present, and then I'll have them report back.
Okay.
And would you mind waiting just a moment while I verify that?
Nope, not at all. And Commissioner Carmy is explaining protection orders right now, so this might be a great time.
Good. I'll hustle over there. I'll stop my video and be right back. All right, Madam Clerk, let's go on the record. It looks like Ms. Gronitz and Mr. Bopp are here. Ms. Gronitz is joining, although it's slow.
We are on the record.
Okay, we're reconvening in the Mandy Gronitz and Nathan Bopp matter 23-3-34408. Ms. Winkles is present. Mr. Bopp is present. And it shows Mandy Gronitz is trying to join, but has not yet joined as of yet. So I confirmed with my assistant. She went to Commissioner Carmy's docket, did not see Ms. Gronitz in the courtroom, and Ms. Gronitz was also not on the Zoom call. I returned to my courtroom here, and I see that Mr. Bopp was here and Ms. Winkles was here, and that Ms. Gronitz is still in the process of joining. You know, when it says that a person is in the waiting room and then you admit them and then they're in process of joining. And at this point, the joining has not been successful. So I'm not sure what to do about that, other than I'm wondering if I can send a chat to her. No, it doesn't let me do that until she's actually part of the joined.
I can email her real quick.
Okay.
What would you like me to say?
Oh, looks like she's in.
Oh, never mind.
All right, so she's in now. It's connecting to audio, so maybe another pause as we wait for that. Okay. All right, we're here in the matter of Mandy Gronitz and Nathan Bopp. The cause number is 23-3-34408. We have Ms. Winkles present representing Mr. Bopp. Mr. Bopp is here. And I see Mandy Gronitz is present also. Ms. Gronitz, can you hear me? Let's see.
Ms. Gronitz, can you hear me?
Yes, I can, Ms. Gronitz. Can you hear me okay?
Yes, I apologize. I'm having some connection issues. I was trying to call in to get better clarity. I don't have the right meeting password. So if this works, I'll just go with this.
Okay, that sounds fine. We're here today for a noted motion for summary judgment brought by Ms. Winkles on behalf of Mr. Bopp. Ms. Winkles filed on behalf of her client, she filed a motion for partial summary judgment, also a memorandum of law, which is just one document. And then she filed a number of supporting documents. And it looks like those are served upon Ms. Gronitz. And then Ms. Gronitz, I didn't receive anything from you. Did you file anything in response to the request made by Mr. Bopp? Ms. Gronitz?
I don't believe you have submissions for this particular issue.
Okay, so the only thing I heard, you may have been speaking for a little bit. The only thing I heard was this particular issue, that phrasing. So if you said something before that, if you could repeat it, please.
I believe we're going to run into connection issues. Is there a way to call in and get a better reception?
There is. If you...
I'm missing the meeting passcode. The passcode I have has initials and it's saying it's the wrong one when I call in. I have a 821820JC2020.
Yeah, I have. Yeah, so again, meeting ID 863-043-0413. And then
yes, it's the
passcode
passcode.
1820 J as in John, C as in Charlie, 2020.
And when I enter that, as I call in, it won't accept it in the call. I've been trying for 10 minutes.
Okay, I'm just going to experiment and make the call using my phone and see what happens.
Your Honor.
Yes.
The passcode at the bottom of the screen, it says 348531.
Oh, yeah, that may be. It looks like there's a passcode for the Zoom, apparently, if you're for the video and audio. And at the bottom, following the listing of various phone numbers, there's a passcode of 348531. Thank you, Madam Clerk. So maybe, do you want to give that a shot, Ms. Gronitz, and call one of those phone numbers, use the same meeting ID, and then just use that different passcode, which is 348531.
Yes.
Okay. I'll just wait for a bit and then you can do that and then let us know how it goes. All right, let's go back on the record.
I'm here, Your Honor.
Okay, very good. Thank you, Ms. Granite. So I'll just get the clear from the clerk that we're on the record and then we'll commence. Okay, great. Thank you. Okay, so let's just start afresh. Again, this is Mandy Granitz v. Nathan Bopp, cause 23-300-34408. Ms. Winkles is present, representing Mr. Bopp. He is also present. Ms. Granitz is here. And just confirming, Ms. Granitz, you can hear me okay with the phone?
Yes.
Very good. All right, so we're here today on a motion for summary judgment brought by Mr. Bopp via Ms. Winkles. I reviewed the motion for partial summary judgment and also the accompanying supportive documents. And I wanted to check with Ms. Bopp, did you file anything? Because I didn't see anything that had been filed in opposition.
My filings have not been submitted to the court on this case. I've been working with the other cases and trying to work with the attorney separately. The issue at hand is separate property that she's arising. That's not technically the issue that we're facing on this case, but what I'm reading is that she's trying to identify Mr. Bopp's separate property prior to the CIR, and then we've had an issue of exchanging property. I've had his stuff, he's had my stuff. I've coordinated a third party to make exchanges for the separate property. So this motion for summary judgment is premature and not really relevant to what we're trying to solve on the case. But as far as property before the CIR, I haven't argued that. We just haven't identified what is and isn't separate property yet.
Okay, so at this point, what I have before me, Ms. Granitz, is that I have Mr. Bopp's version of events, and the rule CR 56, Civil Rule 56, indicates that there has to be specific pleadings or affidavits that set forth specific facts showing that there's no genuine issue for trial. And that's kind of the standard we use. So if there's not a response, it says if the adverse party here, you're the responding party here. If you don't respond, it says summary judgment, if appropriate, shall be entered against that adverse party. So without any pleadings on your end, Ms. Winkles is entitled to judgment. Can you tell me?
However, this is a notice of unavailability. I put in a notice of unavailability 3 weeks ago. I've asked for a continuance 5 times so that she and I can get on board with each other about this. So the fact that there's trial today, it goes against my notice of unavailability.
Well, let me just read it to you, and because I had a question about that. When I read over I did notice your notice of unavailability that you did file. You filed 2 of them. I'll take a look at the most recent one, which was filed on October 20th. It states, please take notice that commencing October 12th and continuing through November 13th, Ms. Granitz will be out of the local area and unable to attend in-person conferences, court dates, or the like. Petitioner, Ms. Granitz, will maintain accessible and responsive to court matters via phone or internet. Petitioner will continue to actively work on case file resolution options during this period. So what that tells me is that you're not available for in-person. Like if we were to meet here at the Hall of Justice, you're telling me you can't do that. And then you're also telling me that you will continue to actively work on the case file and you will maintain accessible and responsive to court matters via phone and internet. So by your presence here today, I'm assuming that notice of unavailability as filed applies because you're not here physically, but you're here electronically or via phone. So help me understand your position on that.
My position is I'm working remote. I have 80 hours of discovery to get to counsel. I've had a handful of court dates thrown at me and a handful of basically what I call red herrings, preventing me from getting her the discovery that I need to get to her. So in the last 2 weeks, I've had to field 100 hours of work to overcome the 80 hours of discovery. So everything that's happened in court, which is a handful of motions and gestures on opposing parties' part, knowing I'm not available, pressing for discovery, and not allowing the discovery process to take place. So I put in the notice of unavailability with the intention of working with counsel to get the discovery information to her that she needs to support her case, because she doesn't have the right support data yet in her possession, and I need to get it to her. And every time I have to come to court over a different motion, which has been a handful of times the last couple of weeks, it stalls this process of discovery. My priority is discovery. Her priority is pressing forward and not allowing it to happen. So I am requesting to have the discovery and have the cases actually match up, because her information is not true, not accurate. I have the true and accurate information. And I think that if she had the information, she could better position herself and her client.
All right, thank you, Ms. Kronitz. One question. It looks like on September 29th, there was a docket notice sent to you indicating everyone would be joining together on October 11th to choose a date for the summary judgment motion. On October 11th, Mr. Bopp was present, Ms. Winkles was present. You weren't here, so the court went ahead and set the summary judgment for this week. And then on October 31st, we met again after having the case be heard back on that date. Mr. Bopp was here, Ms. Kronitz you were here, and we set it for today, confirmed that they would happen today. So at that time,
this is the first time I've actually been able to log on. So I was present both those other meetings, but I wasn't able to actually have a voice in those meetings. And it's been communicated several times to get a continuance, both with Ms. Winkles and to the clerk's office, because I was not able to get on, because I am unavailable. I'm working remote, and I don't have good service, and I don't have availability or a way to get to where I can until the 13th. So everything, all these court dates needed to be postponed until the time I could actually get reception to make it to the hearing and have a voice in the hearing. Because it's frustrating to hear you guys make these judgments and not be able to actually say anything when I'm sitting there watching it. I was there the last meeting. I couldn't unmute. And so they pressed forward and pressed forward. So we can continue to press forward, but it's not in Mr. Bopp's best interest to do that. And I'm trying to make it clear to his counsel that her pushing her agenda is not helping her client. Now, if she wants to push her agenda and make the summary judgment, I have to take repercussive measures to correct the efforts that she's putting forth to press this forward.
Okay.
And that doesn't look good for her client. So I'm in a position where I'm trying to help her client more than I feel like she's helping her client. And I'm about ready to check out, because I'm done everything on my part to be cooperative and to be assistive in this. And I'm getting nothing but pressing and resistance and a drive. They're wanting to drive this case. This case has 30 line items. The writ of replevin, which is consumed the majority of the time, has 80 line items. And then the protection order docket has about 60 to 80 line items. So out of the 3 dockets that involve Mr. Bopp, this case has been the most neglected, and now is getting pressed forward above the other ones so that she can motion for separate property with the full intention of having me arrested for the property that I'm possessing of Mr. Bopp that I just unloaded at his house. So I'm looking for a fair and reasonable outcome. They're looking to have me arrested so Mr. Bopp doesn't have to have a divorce or pay me the 1099 he's outstanding from last year. I have a federal tax evasion issue I've been trying to resolve. I have to let the IRS know, are they taking measures, or am I fixing this here?
Ms. Gronitz, do you mind if I just interrupt just shortly?
I'm done.
No, it's okay. We were talking about your presence at a couple of different hearings. On October 11th, there was no showing that you were present. On October 31, there was a comment by the clerk that you were present, but not responding, and that could have been due to internet connectivity issues. So I just wanted to make that clear. So we've heard from Ms. Gronitz. I'll hear from Ms. Winkles, please.
Yes, Your Honor. The issue I have is, even if she were present or even if she weren't present, the fact is that she has to submit something. You don't just get to go to court and say whatever, because then it's not properly before the court. So her duty, unfortunately, if you have a lawyer, if you don't have a lawyer, is to read the court rules. And CR 56 is written in such a way that it's pretty understandable. It's deadline oriented. It's you have to file a declaration or an affidavit confirming your side. That is what she needed to do. Even if she didn't show up today, if that were here, I wouldn't just get what my client's asking for, because then you have something before the court. You can make the determination based on the facts before the court. Her argument about she didn't know, she hasn't been able to argue, it's problematic because there's nothing before the court. We have nothing to go on. And I gave Ms. Grunitz a lot longer than the 28 days, which is the minimum. So she's had since September to put in something, and she's put in nothing. I, in fact, didn't think that there was a problem with this particular issue, which is why I kept pressing forward saying, this is such a small issue. This is the 2018 and before stuff. And I'm not asking for it to be returned. Obviously, this is not an injunction or anything of that nature. This is purely determining that anything 2018 before separate property, not capable of being distributed under a CIR. It's a question of law. Anything that was purchased before then, and we have a list. Now, I did expect maybe she was going to put a list in of things that weren't purchased before 2018. She did not. We did put in receipts and the like. There's no question of fact. You have no declaration here. You have nothing here. The court rule is very clear. Even if she weren't here, it wouldn't matter. Even if she came on the 31st, it wouldn't matter because nothing's before the court. So I'd ask Your Honor for a judgment that anything prior to 2018 that's on the list on Exhibit F that's listed as before 2018 is separate property, not capable of being distributed under a CIR, and therefore is not an issue. Then I can, obviously, the replevin, we can see what's actually been returned in that. Obviously, my client's stating that there's not a CIR. That is a question of fact that has to go before a fact finder. It's going to trial. The questions about discovery and the like, that's a completely separate issue. I'm not sure, there was orders in the other cases on when to turn that in. They haven't been met in any event. We're waiting on that. But this is such a small issue. It's a very finite issue. Whether or not they both agree on the date they got together, whether or not anything before that date is capable of being distributed in a CIR. And if the answer is no, and according to case law, it isn't, it's not like a marriage and that you can separate properties on the table. It's only during the marriage or during the CIR. If that's the case, then anything he purchased of the things she took before 2018 are separate property, and he's entitled to a judgment that those are separate property and they belong to him. And then we go from there. Whether or not they've already been returned, I'm not going to go for a replevin on them. If they haven't been returned, then I'll obviously talk to Miss Gronitz and Mr. Bach about that. But this is really just determining if separate property is capable of being distributed in a CIR. And if not, then that should belong to Mr. Bach, and that's it.
Thank you. So, Ms. Gronitz, what are your timeframes? What's the earliest timeframe you can have your material submitted?
Your Honor, I am not technically objecting to general property before 2018. However, there was a 5-year relationship, and the ownership of set items, specifically a handful of tools, are up for question. I have been working to try to return Mr. Bach's personal property to him since June. So in my opinion, this entire case is unnecessary and just excessive litigation. Once I can return Mr. Bach's stuff, I don't know specifically on the list what would even be up for question, because as far as I'm concerned, Mr. Bach is missing a bunch of his personal and sentimental effects from the remodel that took place in March, and I've been working to return those. I know a good majority of those items were returned this weekend. I don't argue to keep anything associated with Mr. Bach specifically. I don't want any of his personal items. So as far as going for the summary judgment, like I said, the whole purpose was to press the summary judgment because I have his possessions so that she can chase after me with a written requiem to say I stole his possessions although they were transferred during a legal remodel. I have legal possession of his items, but I don't want his items, and I'm trying to return them, and I've had counsel in the way of allowing me to return his separate property. So instead of working with me to give him his stuff back, she's pushing all of these legal issues, driving up his costs. He's already paid her more than the property that he's arguing for in this case. So as far as making a judgment on pre-2018 items, generally that would be fine. But there's a handful of tools that I don't know. There's the things on the list. So if we make the summary judgment today of pre-2018 items being his, that's fine. I don't want her chasing after me with the writ of reprimand saying that these items are stolen because they're trying to invade my property and have the sheriff go up and do a search on my property for some other purpose that other than this. It's not about the personal property. I've been trying to get him back his stuff, and she's been blocking my way to press litigation. So my solution is let me give his stuff back, see what we're arguing about after the fact. But I've been stuck with his possessions in my spot, in my storage. My stuff is sitting out in the rain, has been all year because his stuff is in my prime storage so that it doesn't get ruined because it's a client project materials. And I take good care of any client's possessions I assume owners or responsibility for. So
Can I ask you a specific
as
question,
far as
Ms.
I'm
Cronitz?
concerned, the full motion is unnecessary.
Can I ask you a specific question? There is a
Yes.
allegation that there's a boathouse purchased by Mr. Bopp in 2017. Are you contesting that?
No.
Okay. There's a contention that there were tools purchased tools and property purchased prior to 2018. Are you contending that those do not belong to him, or they do or do not?
A handful of tools land in the gray area. I know some of his bigger tools got returned. The table saw that was all of his large items that were easily identifiable for the third party to take back have been returned in my belief, or that was what I was informed yesterday. So he has his table saw. I'd have to review the list, but as it is right now, his items are in my storage. I want them out, and I'm being blocked from returning them while also being chased after for theft. So I didn't steal anything. I'm not necessarily contesting pre-18. However, we did have a CIR. We worked together 5 years, and I have been using tools exclusively to run my business during that time. I don't necessarily want anything. It's a replacement value. We're arguing replacement value only, not the actual possessions or not the actual items.
Thank you, Ms. Cronitz. A follow-up question. You indicated that you'd need time to review the list of tools and property. How much time? This goes back to my initial question that I didn't hear a response to of when do you think you would have your materials ready so we could have this hearing and make a determination, which may, if you get those materials in, may obviate or prevent the need for having the hearing. But I just need a general time frame when you feel you would have your response to the motion for summary judgment submitted.
The response can be submitted Wednesday. I have an agent available to take it to the courthouse. I have to email because everything has to be paper submitted into court. It makes it challenging when I'm 2 hours away. So I can Wednesday I can have that paperwork in. Today I have arrangements to go find good internet to upload all the files to give to Winkles so that we know what we're actually arguing over.
Okay. So you think by Wednesday of this week you could have your materials shipped off and submitted to the court and the other party?
I would like to say yes. I know by November 13th or whenever my notice of unavailability takes place, I can make it back to the actual storage unit and finish getting the possessions that Mr. Bob has. So if we set a date 2 weeks from now, we can have much better standing on what we're actually contesting.
Okay. Ms. Winkles, so I'll just kind of tell you where I'm leaning. I'm leaning towards continuing the motion to a trial setting docket on the 8th of November at 1:30, choosing a new date for a summary judgment motion, which could be as heard as soon as, maybe the 20th or the 27th, I'm not sure, but I'm looking at that and just want to hear your thoughts.
Yes, Your Honor. I think my thoughts are going to be the same, just going off of the court rule. She had a certain amount of time. She's had that certain amount of time since, she had more time. She didn't do it. We keep giving her more time on everything. So if this had been the first time this had happened, I would say absolutely. And I'm very happy to give continuances. I'm personally not getting paid for this anymore because she's absolutely right. By now it's gotten so much because of all these continuances that I can't charge Mr. Bopp anymore. But she's had continuances literally on everything for weeks and weeks. And so I'm just back in court every day. And so for me, I think the court rule should stand. She had a certain amount of time. She doesn't know if she contested or not. She could have looked at that property. She could look at it right now and tell Your Honor, this no, this yes, this no. I mean, it's not a very long list on Exhibit F. The fact is that she's dragging her feet, and it's costing me money at this point and me time. And it's cost Mr. Bopp money and time before that. So I'd ask that she doesn't get a continuance. Putting this back on the trial setting, it's just going to be the same thing. It's the same thing with the discovery. We've been put on, she's gotten 3 continuances. We've been put on. I still don't have it. So now I have to go back to court on that. It just makes this really expensive. And I can't justify it to somebody who's looking for 25 grand worth of property to have a 25 grand bill. It just doesn't make any sense. So I'd ask that it not be discontinued. It's prejudicial to my client, really prejudicial. And because it costs them so much. And Miss Gronitz has the rule in the book. I mean, you can Google it. And the fact is, she could have put a declaration in that said, I don't agree. And these are the things I don't agree on. And these are the things I do. It could have been 1 page. And she didn't do that. So I'd ask that we go forward today. But if we have to set it over, we'll live with it.
Okay, thank you. Well, I don't disagree with the notion that Ms. Gronitz could have filed something, could have filed a note that said, I disagree, or I agree with these certain aspects, I disagree with these certain aspects. But it's been crickets. We haven't heard anything. The paperwork clearly indicates that Ms. Gronitz needs to respond by a particular time frame. That time frame is passed. So I'm gonna put a filing deadline that any responsive pleadings to the summary judgment must be filed no later than Monday, November 13th. That's the cutoff date. So Ms. Gronitz, make sure you have it filed by that time frame. We'll be back here on November 15th at 1:30 to choose a new date for the summary judgment motion. I am also assessing $500 of attorney fees that Ms. Gronitz will need to pay to Mr. Bopp for the dilatory action or lack of action. So Ms. Gronitz, November 13th, I give me a little extra time. You said on the 8th you'd have it ready. So I'm going to give until Monday the 13th, close of business. Everything will need to be filed and shared with the other side. We'll be here on November 15th at 1:30 for the trial setting docket, at which time we'll choose the summary judgment motion date and the $500 for attorney fees. So I think that's any clarification or questions on that issue?
No, Your Honor.
Ms. Gronitz?
May I request that they stop putting in frivolous motions? I offered relief to return his stuff, and she filed sanctions against me for discovery. So I'm trying to return the things that we're arguing about while she's trying to sanction me for not responding. So every part of her litigation has been counterproductive for her client because all she had to do was allow me to return his items in June and not press all of the excessive litigation. So in this particular case, what you have in front of you is very little information. But on the other cases that she's been preoccupying my time with, she pulled in the protection order docket when it was supposed to be sitting idle and I wasn't supposed to be attending to it. So I've had to give 50 to 60 hours to that docket.
I apologize for interrupting. My question posed was, do you have any questions or clarifications related to the court's order today? A set of the deadline for filing,
Okay.
the date for coming back for the summary judgment motion, and the $500 attorney fees. Any questions or clarifications about that?
What I hear you say, Your Honor, is Monday the 13th, I need to have my response to the summary judgment turned into the court. We
Correct.
meet again November 15th at 1:30, and I'm getting charged $500 attorney's fees. Is that correct?
Yes.
Okay.
All right, hearing no questions, that'll conclude the hearing today. Thank you.
Thank you, Your Honor.
Are we still doing the protection order?
Yeah, the protection order, my understanding is that it's that it was arranged beforehand and that that's still a go in the different courtroom.
Yeah, and I'll be
Well,
moving
how do
over
we,
there
so
now.
do I log off and log on to something else for that, or do we continue that?
You'll have
That's
to
a
go
different
to,
docket, right?
yeah, it's a different docket, so you'll have to go to the court website and find the protection order docket link and or phone number and scroll all the way down to the bottom to make sure you got the correct meeting ID and code.
Okay, they were just at the exact same time, so it was really poorly scheduled.
I think it was scheduled perfectly, and then we've made accommodations for everybody to participate.
Number 13, Mandy Grounitz, Nathan Bopp. I believe I saw Ms. Grounitz log in, and Mr. Bopp is represented via Ms. Winkles. I have set for summary judgment.
That's correct, Your Honor. We already went in front of Judge Evans. He wanted to give Ms. Gronitz more time, and then he put us back on this docket to reset it. I asked that it be on his again because he's probably read the pleadings already.
And how far out are you looking?
As soon as possible. And that's another issue. Ms. Gronitz put in a 60-day notice of unavailability, which I would ask that that be ignored. We have Zoom. A week or 2 weeks is adequate. 60 days at that point, you might as well put in 6 months.
Yeah. Hey, Ms. Grounitz, can you hear the court?
Yes, can you hear me?
Yes, I can. So it seems like this is something that had already been in the works. And I'm hesitant to set this out 2 months. Wherever you will be, are you able to log in via Zoom?
The Zoom isn't the issue, Your Honor. The issue is 36 court dates in 24 weeks is not allowed proper time for discovery development. And I require proper discovery development time in order to see the case. Today's issue is about separate property. We can address that today. But to go to trial for the CIR in completion, I have a new information that was brought up last week. And I have there's several working parts on this case, and it's unfortunately I've had to contact alternate counsel's investigative help to better present the full dynamics of what's going on in the CIR to go to trial.
Okay. And as I understand,
did you get the packet of information that was dropped off to court that isn't in the system yet?
I understand
I
that.
turned in
Okay. I'm looking at
Did
the
you get the response?
I'm looking at the motion for summary judgment that was filed on September 29th. That is the motion that we're working on for trial setting, correct?
That's correct. And she has put in a response as well. There is a response now.
Does the judge have that because it's not in the court system as entered?
I think it just came to me today. Is that the response that you would have filed within the day or two?
Okay, it was submitted to court Monday, so yes, if you just have it now, court I believe was closed on Friday, so it got submitted Monday, which kind of cut your time short to review it. I apologize.
Well, no, I'm not hearing it today. We're setting a date for it to be heard. So because the motion's been filed, there's been a response. I am going to go ahead and ask the court for how much time did you want, Ms. Winkles, on the summary judgment motion?
An hour, not an hour would be reasonable. My argument will take 10 minutes,
Okay.
if that.
We'll set this for 1 hour with Judge Evans.
So I'm looking at the week of December 18th.
Is there anything earlier, like the week of November 27th, just for an hour?
No, we don't have Judge Evans available that day.
Ah, okay. I'm actually in trial the week of the 18th. You know, if it's possible to go in front of somebody else, the pleadings are short. I just don't want to put it out that far, considering there's so many other hearings in this case. I'd rather get this one over with, so we can put it on in front of any judge.
I still think we're looking at the 18th due to judicial availability.
Okay, I'll take it. I have a trial, but it's only an hour, so.
Okay, so week of December 18th, and then we'll do readiness on December 12th at 11:30.
Okay, thank you.
So Ms. Groundus, that means the summary judgment will take place sometime the week of December 18. You need to log in for readiness. Danielle, did you say December 12th?
Yes, at 11:30.
Ms. Groundus, log in December 12th at 11:30 for readiness, and we will determine what specific date your case, your summary judgment will be heard, okay?
May I still additional information? I still have declarations to submit for the readiness.
Okay, that's fine. I'm not hearing any of that today. This is simply a trial setting docket. So file what you need, what you think you need to file.
Thank you.
Okay, thank you.
They had another review hearing on the request for attorney fees, but I don't have that docket. However, we can see in Odyssey that Commissioner Carmi had enough of this messing around and ordered her to pay $4,395.
Still in a breakout room. So I do have a summary judgment motion. I'm going to put you all to the end of the docket since I know you'll be the kind of longer matter today. I have one other matter to take, Ms. Winkles. I believe that's with you, Mr. Bopp, and Mandy Grounitz. I believe she might be the phone number that's logged in. The phone number.
Ms. Grounitz, can you hear me?
Yes, Ms. Grounitz, I can hear you. This is Commissioner Jill Carmi. Let me just pull up your file. This is 232-0053908.
And Your Honor, just so you're aware, we tried to file with the court what we had received, so that, you know, there was some information backing us up, but the clerk would not take it, and I can understand why, and I can get to that, but just so you're aware, if Your Honor does want to see it, we tried.
Okay. Yeah, I'll just note we're on for a review hearing. We've had kind of a continuing question about Ms. Grounitz's full compliance with discovery requests. We've had multiple hearings. Essentially, I think the prior request that's continued through today is the entry of a default order for failure to comply as a sanction. We've talked about attorney fees, which are probably going to be granted no matter what we do, given the steps that Ms. Winkles and her client have had to go through to get to this place. But Ms. Winkles, I'll turn it over to you and see where we're at.
Okay, so, you know, we did file what we were asking for. And so just so Your Honor's aware, we cut down our discovery request a long time ago with the initial hearing with Judge Basher. They were only documents that we wanted produced. We did not ask for any answers, written out answers, just documentation. We have received answers to things we didn't ask. That's the only way I can explain it. We've received things about her mother, where her mother went to school, things about her college degree. We've received the photocopies of college books she's had, her syllabus from 1994. We've received the bank statements that we subpoenaed, gave to her, but with those changed, some of them pulled out. We've received no receipts. We've received copies of his work schedule, nothing about her. Essentially what we've received, the only stuff we've received is stuff that we gave to her and back, or stuff we never asked for. But what we haven't received are the bills, the W-2s, the 1099s, the agreements, the written joint agreements, the police reports, the pleadings, the Facebook account, which is interesting because she actually contacted us and asked how to do it. We informed her, my legal assistant walked her through, never received it. Any psychological opinions, and there have been a few, schedules for 2 years, income for 2 years, public assistance, EDD stuff, which we specifically asked about, photos. We got 5 photos, not the photos we asked for. We are told all of this existed by her. So, and on her answers, if she had said no, don't have any, fair enough. These all said reserve. And that's the whole point, is that she could have reserved them at the beginning and then tried to, come back and supplement it. No, you can't. Now is the time to answer, not to reserve. The things I need in order to put this case on, I don't have. So the only things I do have are the things that I'm able to subpoena. So I'm able to subpoena her bank statements. I have their bank statements now. I'm able to subpoena no taxes. The federal government won't let you. I'm able to subpoena none of her income, her jobs, because none of that. I can't subpoena Facebook. They won't allow you to. We tried. I can't subpoena the photos that are in her possession. The thing is, she makes statements under penalty of perjury that this is all stuff she has. What she submitted to me, I can only explain in that, for example, if I asked for a bank statement, she would send me back a spreadsheet in her own handwriting of what the bank, she's saying the bank would take, but not the original document. So I have 25 pages of writing of Ms. Gronitz to production, request for production. I don't need her stuff. That was the whole point. I have 10 pages of statements from spreadsheets that she claims are like the bank statements, but I wanted the bank statements. I have a lot of her own production. I have none of the original stuff. I have, what I can only explain is she wanted to submit something. She submitted over 20 emails to us. And of those 20 emails, none of them, well, no, one of them had at least our bank statements back in them. But of those, probably one had documents I requested, and the rest were documents nobody ever asked for. Things going really down a rabbit hole of like what she studied in college. We asked her for her degree, a copy of her degree. We got everything that ever led her up to that degree, including all her class materials. So I'm still in the same place. They were initially due October 25th. They weren't received into our office until October 30th. Your Honor said, October 25th. October 30th is when we got what we got. And then we sent it out again. Then they were due again by the 17th. We granted an extension till December 4th. We've been in court so many times, and of the questions we asked, 38, she's produced approximately 11 of those. And of those 11, 8 of them were documents that we got by subpoena and gave to her, and she just gave back. So really, she's answered 3 out of 38. And we're still in the same boat. I have no receipts. I have no proof of what people owned at the beginning. I have no proof of anything they engaged in together. I cannot answer. You can't get a replevin when you have a CIR. I can't answer the CIR because I have no information about it aside from self-serving statements. I have no documentation whatsoever that didn't come from my client. So I'd ask for the same thing. I'd ask for a default at this point. This is a default in the replevin. So this defaults the possession only. It doesn't say who is entitled to it in the end. It only says whose possession. Now, I do want to remind Your Honor that Ms. Gronitz has said repeatedly that she's going to drop these things off at my client's house. Everything. I don't know why we're here. I'm dropping these off next weekend. They aren't there. This would make them be there. It would be a default in the replevin. So these items would go back to my client with the police. And then at that point, we still have the CIR. She wouldn't be defaulted out now. We still have to argue who is entitled to either compensation for them or the overall ownership of them at that point. But at least the possession, I don't even know why we're here. If these things were supposed to come back so long ago, the replevin would have already been handled. So I'd ask for a default in this case. I'd ask that we get our order of replevin to have my client be able to go out with the police and get these items returned to him. The list has stayed the same since the beginning. This is a discovery sanction. She has another chance to fix this in the CIR. And I'm hopeful that she will, so that we can actually finish this once and for all. Thanks.
Thank you. Ms. Grounitz, what can you tell me? I know we had a pretty pointed talk when we were all last together about how I needed you to comply with discovery. We've had since at least August, CR 26 conferences followed by discovery motions, and it it does seem as if the answer is always that you're working on it. Where are you at?
Well, good afternoon, Your Honor. I'd like to ask Your Honor's permission to listen to my position as I speak in the language I'm familiar with. I do business management, accounting, general contracting. That is the arena that I'm accustomed to, and I know it doesn't directly translate into legalese. However, in order to explain where I'm at in this case, I need to use the language I'm familiar with. If you can please just give me a second to brief you on what's been going on, then you can translate that to what position we get to take at the end, because I'm in a dilemma where I'm caught in a catch-22. So I work on the numbers, and yes, counsel admits I took an exorbitant amount of time to download each and every transaction from my bank, compile them into a spreadsheet, separate them into a budget, and send that information to her, separated deposits that I have made on all my accounts, separated potential construction materials at question. I haven't matched every client customer to each deposit yet. It's an activity that takes time. I haven't matched every receipt to the spreadsheet she's gotten, but she has a complete list of every deposit I've made, every potential item for customer materials that could be in question for improvements of the home. That satisfies the bank statement. She has all the physical accounts of my banks, and she can quickly look at the deposit amount on the bank statement and verify it with the spreadsheet I sent her to notify or verify that the information on the bank statements match exactly the information in my spreadsheet. There's a lot of information in that spreadsheet. She wants to actually take the time to review it instead of just questioning its authenticity, because the numbers should all match. She has all of the bank accounts, all of the physical statements. Today, I present a conflict of litigation agendas. I am both in the issue of returning Mr. Bob's items to him, which takes now my personal attention, because I notified counsel about a month ago that I was liquidating storage units at Mount Brinian. We were reallocating. I've had my family move out. I've had to hire people to swap storage capabilities between assets getting sold and assets intended for long-term storage. Assets intended to get sold have been removed from Mount Brinian, and at the time I offered to return Mr. Bob's items to him, we were discussing how important it was for me to work on these reports. So my personal time has been spent on personal reports. Thus, everything from Parkview is now grouped into a storage unit for liquidation. I personally have to go through that stuff to discern what belonged to Mr. Bob versus what didn't. I submitted the list of items to the person in charge, but it's up to them now to look at the items and see what was his or not. So I can either satisfy counsel's request and continuing doing discovery, or do what I proposed to do last month, which was try to go through what he had or what was in storage from construction in May and return what items I could. But we keep coming back to court, so I can't spend the time to give him back his stuff. In court. So do I write reports? Do I go spend time sorting through his items? I start a customer job next on the 22nd. I'm contracted to go do 8 weeks worth of work. I won't be touching Mr. Bob's items after that. So whatever the court decides, I don't have the capabilities of satisfying the court's request of returning his items after this weekend. This weekend is great, but I have court now Monday. So now I'm preparing for court Monday instead of trying to get his assets back to him, which is the priority. Paying counsel to block him from getting his stuff back, or allowing me the time to return his stuff and just negotiating our wage claim. That's where I'm at. I don't know. But I have court Monday, so right now he doesn't get his stuff back because I have to litigate instead. I'm frustrated. I don't want it. He wants it, but here we are litigating. How does this solve it? I don't know. I need a solution. I believe he wants his stuff back. I don't see anything that he's gaining by paying to block himself from getting his stuff back.
Yeah.
But here we are litigating, and it's cost me $60,000 in earnings potential this summer, and I'm done spending my personal time putting my clients on hold. My clients have now taken precedence. They want to give me money to go help them. I'm going to go help my clients because Mr. Bach obviously doesn't want my help. And I don't need to spend my time on somebody who doesn't want me helping them and isn't going to pay me. So a third party can distinguish what he has on his list. I was going to offer whatever I could find, which would be a lot more on his list than whatever, because everything in our whole house got boxed up for construction in May. I don't even know what's in there. My stuff, his stuff, the kids' stuff, everybody's stuff's in storage. It's all jammed up. Nobody's benefiting from any of this litigation. I'm keeping all this stuff jammed up. But I liquidated. My business structure is back up and operational. I'm not using our assets to block my business anymore because I have to go back to work. So my clients take precedence. Mr. Bob is choosing to litigate.
Okay.
That's where I'm at. I don't know.
Okay. All right.
What
Thank you,
would
ma'am.
you guys want to do about that?
Okay. No, I appreciate that input. Ms. Winkles, anything further?
Oh, hold on one second. There we go. Yes. Here's the thing is we've been told that this stuff is going to be returned for months. I mean, we've been here for months and yet it never shows up. My client has been there waiting around on weekends where we're told it's going to come, it never comes. We're told we're going to get discovery, it never comes. All of these hearings could have been accomplished. It could have been if she had sat down and got, taken the documents rather than making a spreadsheet of what the document said. She had just given me the documents. I have AI. I could have stuck it in the AI. It pops it out itself, but nobody has to do anything. 10 minutes. The fact is that we still don't have anything. As much as I would love to, base everything on what people say and trust that the spreadsheet is correct, the fact is I can't do that. That's why we asked for the documents. We're here because she hasn't done what she needs to do. This is the same for everybody. It's the same for if you have a lawyer. It's the same for if you don't. It's the same, the amount of time we spent in court, she could have gone over to the bank and she could have gone and gotten her receipts and she could have gone, to Home Depot like my client did and asked for his, his account information from them. You don't have to subpoena them. There's so much that she could have done that she hasn't. So I still ask for the writ of replevin, the order for the writ of replevin and the default, mostly default first, because here's the thing. We're going to be waiting for her to get these things over when the police will go over there with Mr. Bob. He'll take a trailer this weekend or within 10 days and he'll get his stuff back because the police will allow him to. They'll have an ascertainable list in the form of the complaint. It says everything that's there. We know where it's at on her property. And that's the end of this. And it should have happened a long time ago, but we were hoping, that's why I wanted them consolidated, these cases. But we are where we are because of no fault from my clients. This is Miss Gronit's rate, making the bill go higher and higher and higher because she just doesn't want to answer. And so I'd ask Your Honor to do the default. It will have been, I'm almost somewhere around 7 times in court for discovery. And we are now, I think we served it on her months and months ago. So, this is like, so we're in December. This is like 5-6 months waiting for receipts. It's frankly ridiculous. So I'd ask Your Honor to enter the default and then immediately thereafter enter the order for the writ of replevin. And we can fight this out in the CIR, but at least that part will be done. Thank you.
Okay, so Ms. Grounitz, Ms. Winkles, here's my ruling, and it is fair to say that we have been here numerous times. I think this case was originally filed in June of 2023. I believe the amended complaint we're working off of is dated July 5th, 2023. There have been several show cause motions without really substantive responses, except a lot of the same things we're hearing today along the lines of there's just so much litigation that Ms. Grounitz can't possibly find the time to respond. I would note several CR 26 conferences have been noted by Ms. Winkles, and then discovery motions filed in this court starting in, I believe, August of 2023. I will note that at some point in time, this court did enter an order requiring pre-filing restrictions on Ms. Grounitz, just simply because of the unrelated filings that were coming in, the unrelated responses. There have been numerous orders to compel. All of this to say that it is very clear to this court that no matter what we do, pre-filing restrictions, orders to compel, attorney fee sanctions, more likely than not, Mr. Bopp is not going to get any of the discovery or responses that he is requesting. I believe more likely than not, if I don't grant the request for default, essentially as a sanction for one blatant and ongoing discovery violations, but also based on a finding that Ms. Grounitz has not materially or practically been involved in this matter in any degree that advances this case. I think we'll just keep doing this for months and months and months. So I also take into account that the nature of this cause is for replevin. I think that, as Ms. Winkle states, that does leave room for Ms. Grounitz to pursue her arguments in the CIR matter if she chooses to do so. And frankly, I also take into account that Ms. Grounitz essentially numerous times to this court has agreed and admitted that many, if not all of the items requested in the complaint for writ of replevin are Mr. Bopp's. So for all of those reasons, I am going to grant the request for an order of default in this matter. And then once signed, Ms. Winkle certainly can decide to file for the writ of replevin should she choose to do so.
Mr. Bopp denied receiving any of his items to date, or is he going to contest that everything on this? I've returned almost everything, but like $4,000 worth of stuff, Your Honor. Do they not counting that? I've spent all the summer returning this stuff, not litigating over it.
Yep. So, ma'am, what I am doing, my ruling is as stands. I am for the.
He's not going to find his stuff even if he goes to the storage unit. They lost that opportunity 2 weeks ago. It's not there anymore.
Ma'am, I'm going to go ahead and mute you if you don't let me finish. So my ruling.
Okay, well, he won't get his stuff back.
Okay. Ms. Grounitz, I have muted you. I am ending this hearing. I have made my decision. I will sign the order for default once received. Is there anything else that the parties need? I'm not, Ms. Grounitz, I will allow you to unmute, but I'm not taking further argument. I'm just asking if any party needs anything else from this court.
Not on our part, Your Honor.
Ms. Grounitz, anything else before we end this hearing?
The items are not where they would send the sheriff to get them. If they want the items back, they need my help to get them. So you can write the writ of replevin and you can send the sheriff, but it's not going to help him get his stuff back. I'm sorry. I told her this 2 weeks ago. I'm trying to get his stuff back, but it's,
okay. All right.
I need to go do it. So
Understood.
I can do it this weekend if they want to just drop court Monday, or we'll do court Monday, but I won't have any more information to the courts. I'm gone.
Okay.
This whole thing has been frustrating because I can't get my information to the court.
Understood.
I'll take in the discovery. She has all my statements. It's frustrating.
I understand, ma'am. My ruling.
Okay, so write the replevin, but he can't get his stuff back.
All right, ma'am, I have muted you again. I understand that there's nothing further that the parties need from me. My ruling is as stated. Thank you, and you are free to log off.
Thank you, Your Honor.
Thank you.
As she mentioned during the hearing, the commissioner ordered the default and a writ of replevin. That was the final hearing for Mr. Bopp's motion. But she also ordered Mandy to pay another $1,500 in attorney's fees. Mr. Bopp's case is over now, but Mandy's motion soldiers on. There was another summary judgment hearing with Judge Evans, but I don't have that hearing. Mandy must have continued to play games with the court because we can see in Odyssey that he granted the summary judgment.
Ms. Winkles, can you hear me okay?
I can. I hope you can hear me. I'm having internet issues.
Yes, I can hear you just fine. And Mr. Bob, can you hear me all right? Okay, great. All right, so we're here today for presentation. I received a proposed order granting partial summary judgment, and I also received from Ms. Winkles the objections or concerns raised by Ms. Gronitz via email. So thank you for forwarding that to me. Have you had any contact with Ms. Gronitz this morning or recently about whether she's planning to attend today?
No, I have not.
Okay. All right. So Ms. Gronitz raised three issues. One, she believes that the commencement of the cohabitation should be March of 2018. The evidence at the trial and my finding was that it was mid 2018, so mid is June. So I'm going to leave it as June 2018. She also raised issues of the sauna and the 1969 Ford, that should be involved in the property distribution in some way. However, to my recollection, there was no evidence produced at trial regarding the sauna nor the Ford. So I'm not going to include the sauna nor the Ford in the distribution order. She raises a third issue as far as tools, some additional tools from 2018. I believe that they should have been included as separate property. The court ordered Mr. Bob's list of property. I think that was Exhibit F. So that remains unrebutted, and there wasn't any evidence to the contrary. And there is Ms. Gronitz now. So I'll let her in. All right. Good morning, Ms. Gronitz. Can you hear me okay? This is Judge Evans.
Yes, Your Honor.
All right. Good morning to you. On the line with us, we have Mr. Bob and Ms. Winkles. I had just, we started at 8:45, so I was just going over a few things. And so I'll rehearse everything that I said in your absence. So we're here today for a presentation for the order that grants partial summary judgment. I received a proposed order from Ms. Winkles, and I also received your concerns or objections to that order that Ms. Winkles forwarded to the court via basically a copy of your email. So just want to go through those objections and the concerns that you raised in your email. So the first item that I noted was that you felt that the cohabitation start date should be March of 2018. In the trial, the evidence that was produced was mid 2018 as the start date, and I think there's even some testimony related to June. Nonetheless, that's my ruling that it's June of 2018. That's the start date of the cohabitation. The next issue is the sauna and the 1969 Ford. That was an indication that was those two items were purchased in 2018, early 2018. At trial, I don't recall any evidence related to the sauna nor the 1969 Ford, and I just want to double check with Ms. Gronitz if it's your recollection that there was or was not any information related to that raised at trial or during the trial.
I don't believe those two items were brought up in trial. I brought those up separate from the trial discussion.
Okay, all right. So since the well, I say trial, I should say summary judgment motion. So since this order is based on what was produced during that hearing, I'm not going to make any adjustments to include the sauna nor the Ford in the ruling. So since there was nothing proposed during that hearing, I'm not including the sauna nor the Ford in my ruling. So then the third item that Ms. Gronitz raised were some tools on the Coal Creek residence related to those that they were purchased. So it sounds like that was a request to include those as Ms. Gronitz's separate property, or that they should somehow be included in the distribution of properties. So at the motion, I adopted Mr. Bob's list of property that he presented because there was no additional rebuttal evidence to those tools. So I'm leaving that as is as the Exhibit F, basically is the listing of the property that I'm adopting. So one thing I wanted to just mention, Ms. Winkles, is that in your proposed order, it mentions Exhibit F. And I'm not sure if it was your intent to include and attach Exhibit F to the proposed order.
It was.
Okay. Is that something that you could forward to me so
Yes.
I can attach it?
Yes, it should have been attached. My apologies that it wasn't.
Okay, great. I'll look forward to that. Will you be sending that via email?
Yes, we can send it via email. Absolutely.
Okay, great. So once I have that, I can file that, attach it to the order and sign up on the order and then submit it for the clerk for filing. I want to double check with Ms. Gronitz. Ms. Gronitz, do you have any additional items that I may have missed in that email that you sent to Ms. Winkles?
I apologize. What do you mean? Do I have any additional items to contest or to add or?
Yeah, good. Yeah, thank you for the opportunity to clarify that. So we're here for a presentation, basically a summary order of what the court ruled at the motion for partial summary judgment. So I have that proposed order and I reviewed your email to Ms. Winkles, which I consider some of your objections or concerns related to that proposed order. So are there any other items that you feel that Ms. Winkles did not get right or did not include in the order for partial summary judgment?
I don't believe so. As I stated previously, I'm not contesting the items, and I want to make a note that the items that were on the tools on Exhibit F are now in Mr. Bob's possession. I'm needing to calculate my losses, so I am looking at what I would have had I not been cut out of this 5-year partnership. So as far as the tools and the property go, we're just putting it on the record. He's got possession. He's going to maintain possession. We're not arguing over the stuff. I don't want any of this stuff. I just need paid back. So I believe that we're in good shape. I don't think there's anything for me to contest, but I wasn't interested in contesting the objects to begin with, so.
Okay. All right. Well, thank you for that input, Ms. Gronitz. I'll once I receive the Exhibit F from Ms. Winkles, I'll attach it to the order that was proposed. I'll sign off on that order and submit it to the clerk for filing. So I think that concludes our activities for this morning on the presentation docket. Ms. Winkles, any final items?
No, Your Honor. My apologies for that not being attached. We'll send that to you ASAP, and we'll include Ms. Gronitz on the email.
Thank you. Ms. Gronitz, any final items?
May I ask? I'm sorry.
Yeah, go ahead.
There's an affidavit of destruction I keep seeing on my case files, but I haven't seen that. Is that the same affidavits, or are there multiple affidavits floating around? I'd just like to request those. I'm seeing them online, but I haven't received them in my the mail or.
So tell me what you're looking for.
When I go on my caseloads, there's the counsel or there's an affidavit of destruction listed, and I don't have that in my files of information.
Okay, I think I know what you're talking about. There on December 20th, there was or the 22nd, a document was filed. The title of it is Stipulation on Order for Return or Destruction of Exhibits. That's the document you're referring to?
I don't know. I just, on 1108 and 1226, both, there's different affidavits of destruction on them that I'm seeing. But if I could just request a copy of those, that'd be great.
Yeah. So what I would encourage you to do as an option, you could check with the clerk's office and they could help you with obtaining copies of that either through Odyssey or getting a copy from them, because I do see the one order there's a stipulation in order for return or destruction of exhibits that was filed on the 22nd of December, which says that it's stipulated between the parties. Oh wait, actually that's 1222. Looks like that's, sorry. Let me get to the right case file. I was looking at a different one. I apologize. One moment. Oh. Okay, yeah, the clerk was just sharing with me that there was, it looks like the clerk's office made efforts to contact Ms. Gronitz related to some exhibits. They were unsuccessful in getting contact from Ms. Gronitz, and so they indicated that if they didn't receive contact on it by a certain date, then they would be destroying those particular documents. So that's what you're talking about, correct, Ms. Gronitz?
If that's what you see, all I see is it says that there's an affidavit and then of destruction, and that's all it tells me. So if that's what you're seeing, they have contacted me. There was the wrong cause number or case number on one of the files. So if that's what you believe it to be, that could be the case. I didn't know if there was other declarations or. Yeah. But if that's something from the clerk's office, and that would explain why I don't have it. So if that's what that means, I'll just know that that's what that means. But
yeah, and maybe what you could do is that I'm showing 3 documents. I did just a keyword search under affidavit for destruction. I pulled up 3. One is from November 8th. That's an affidavit related to an affidavit of destruction, and then there's a December 26th affidavit of destruction. And then there's also a second affidavit of destruction on December 26th. So what I would recommend is just, you could call the clerk's office. They could explain what those documents are. And if you need a copy, they could arrange to get copies to you.
Great, thank you. I should have a courier available today. Okay, thank you for that information. I appreciate that.
Okay. All right, very good. All right, thanks. So with that, that ends our discussion of the presentation. So thanks everybody. Happy New Year and safe travels if you're out and about.
Thank you, Your Honor.
Thank you, Your Honor. Happy.
They had a hearing to set a date for another special set with Judge Evans on January 10th, 2024, and a readiness hearing on February 13th. I don't have those hearings, but I do have the special set.
All right, so we're here this afternoon on Mr. Bob's motion for judgment related to separate property and as that relates to a committed intimate relationship. I've read that motion. I've read the declaration and the exhibits of Ms. Winkles. I've reviewed a proposed order, and I also reviewed Ms. Gronitz's answer to the motion and counter. I've reviewed that response, which was a 3-page document. So if there's any other documents that the parties wanted me to review, but I didn't, please let me know.
No, Your Honor, that was it. I guess I would just redirect Your Honor to the order entering the summary judgment on the last motion, the motion for summary judgment, that order entering it, which is what this is related to.
Correct. I was double checking that either I printed that out or I thought it was attached to one of your exhibits, but that may not be the case. Okay. All right. Ms. Gronitz, any other documents that you were anticipating that I would review in preparation for today's docket?
I do apologize, Your Honor. You do not have other documents in front of you. I have been working on findings of fact because I'm trying to catch myself up to speed on the details that have been presented to court on this specific case versus our other cases. However, I'm still filling in that matrix, and you do not have it in front of you today, but there is a distinct dispute of material fact over these items, and I'm trying to identify and quantify what that dispute looks like. It's a valuation issue, not a possession issue. No, short answer is no, you don't have other documents for me. I do apologize.
Okay. And so just to clarify, Ms. Gronitz, you said you were working on basically the personal property, and you are working on assigning values to them?
Initially, this case was brought forth because the plaintiff or petitioner and respondent were in a committed intimate relationship where both pooled resources into joint assets. Those joint assets are what are listed in Exhibit F. So there is mutual interest in those assets. The respondent has possession and use of those assets through the duration of this dissolution, and I won't be disputing possession of those assets. I'm simply needing replacement value out of our partnership to replace those assets because I need my business tools back. I need a vehicle back. I need all the things I bought over the last 5 years. I need a way to replace those items to continue my business. So until valuation of those items is assigned to this case, I'm willing to accept cash payment instead of disputing over the physical items. But there is a dispute in ownership because I bought and earned these items and I have investment value into them. I need investment value back out of them to make my balance sheet and my income statements work out for the next phase of life. So I am disputing ownership of the assets as far as valuation goes. Like I said, he has possession. He can maintain possession of the assets. But until we determine what the valuation and the dissolution value of the partnership is, then it seems premature to just assign him all the assets, all the income, everything from the relationship. I get all the debt and nothing to move forward with. So
Right.
I need to balance it out. And
okay, yeah, I think I understand what you're saying. And let me just maybe pose a clarifying question as it kind of relates to today's motion. In that December 29th, 2023 order that the court entered, it indicates that the property identified in Exhibit F was purchased by Mr. Bob prior to June 2018, but after April 2023 is a separate property of Mr. Bob. And so there was that finding. And so you're talking about the evaluation of those items in Exhibit F?
yes, those items were donated to the business partnership as consideration into the partnership in 2018 when we bought a piece of property and developed it together. So that was his interest into the partnership, was those pre-owned tools that he had to contribute. He brought the tools and materials. I brought the skills and the labor. So those were pooled resources into a joint venture in 2018. They were part of the relationship assets, even though he bought them prior. Now he has a sentimental attachment because he had them before the relationship and he can maintain them. But all of those tools need replaced for my business to continue. So there's probably about $10,000 rough guesstimate of tools listed in Exhibit F that he would claim as separate property, but he donated to our joint business venture, the Coal Creek renovation in 2018. And since that point, they have been mutual assets of our relationship until we separated.
Okay.
So yes, I can test ownership of those, even though they were his separate property, because he used those as his consideration into our contract for the venture that we pooled our resources into.
Okay. I appreciate that explanation. Thank you. Just going to jot down one quick note. Okay, so now that we just established that there's no other documents to review in preparation for today's hearing, I guess it's time for the hearing for the purpose for which we're here today. So the motion was filed by Mr. Bob, so I'll hear first, please, from Ms. Winkles, then I'll hear from Ms. Gronitz thereafter.
Yes, Your Honor. We have an order on entering that motion for summary judgment, granting that motion for summary judgment. That's where the decision was already made as to the characterization of the property purchased prior to 2018. In that motion for summary judgment hearing, property was identified on Exhibit F. That property, the court made a specific finding that that property was separate. When you purchase property, the nature of that property, unless there's, transmutation, which there's not been any allegations of that, there weren't any on that motion for summary judgment, it doesn't change character. The character of property is whatever it was at the time you purchased it. But regardless of that, we already argued that. We had a hearing, 30 days have passed, there was no appeal, there was no motion for reconsideration. There was nothing of that effect. That order is a good order. It is a standing order before the court. The only thing we're here on today is not to relitigate this. It's already been litigated. The only thing we're here on is to make this a final judgment rather than and I say this word wrong every time and I practice and I still can't do it, interlocutory order of the motion, the order on motion for summary judgment just needs to be made final. And the reason it does, there's nothing that would delay that. We've passed that 30-day mark. Additionally, it's real property. There's mortgages that need to be paid. There's creditors and things like that. There is a reason to have this final order. Additionally, we're going to most likely a trial or settlement. And that is why it's so important. Ms. Gronitz has kind of made my case for me. If we keep arguing issues that have already been decided, unless there's a final judgment, we're going to be going back in time and it's going to cost everybody a ton of money for something that was already decided by the court. Findings were already made. We need this final judgment on less than all claims so that everybody is aware of what we're actually litigating on at the time of trial or settlement. So the issues don't get confused and we can deal with 2018 to 2023 things that were purchased during that time and only that time so that we can stay relevant, make the trial go forward. It's really judicial economy, financial resources, the parties, and just pure understanding. So we'd ask that you enter our judgment, our final judgment on less than all of the claims.
And specifically, you're asking that the 2829 Parkview Drive residence, the boathouse and the personal property is contained in Exhibit F be deemed separate property.
That's it, Your Honor. Just exactly what it said in that motion or that order on motion for summary judgment. Exactly that interlocutory order made final, and that's it.
Right.
It should almost be word for word to the order on summary judgment.
All right. And then to Ms. Gronitz's comments earlier, where she was talking about the different values of the property that in Exhibit F. If I were to accept your argument and say the property in Exhibit F is separate property, is there at trial, let's say, at trial, would Ms. Gronitz be free then to argue, yeah, it is separate property, but it had this value and it was used for business purposes, and that value should be taken into consideration if they're for any type of division of dollars or property?
Well, if this were a dissolution, absolutely, separate property is always on the table.
Yeah.
Because this is a CIR, it's more of a gray area. They don't have the benefit of marriage, and that really, they are different. Even though we sometimes blur those lines, it is different living without marriage and living with marriage under the law. I'd say that she still has an argument. There is no spousal maintenance in a case of CIR, so that's going to be a problem. It sounds like what I'm hearing is that not so much of a CIR claim as something of a business agreement, some sort of going concern or something like that. So I guess that would be an argument that she can make, some sort of contractual one. But because it's a CIR, I think she would be precluded probably from trying to get value from separate property. But again, that was already decided. Findings were already made. I guess that's not what we're here for today, because those findings were already made on the summary judgment motion. But I think it sounds like her argument is more of a business argument. I think she's never precluded from making that. If she's claiming a contract, then she's, and he put in this and she did this in exchange for that. I think that's always probably valid, if that makes sense. It was a long-winded way of saying yes, but.
I appreciate the response. Thank you. Anything else you want to say at this point, Ms. Winkles?
No, I just, Your Honor, the problem is this case is constantly evolving and going backwards. My fear is that we're going to be in court litigating property that's probably worth very little for the rest of time. And so I'm hoping that we can slim down the issues for trial, and that's what we're attempting to do today.
Thank you. Ms. Gronitz?
Yes, Your Honor.
Any additional argument or comment you'd like to present on the issue?
Yes, I had some things to say. Sorry, let me just, writing a couple things.
Okay.
Okay. Let me consider what counsel just said, and I have to adjust what I have to say. Okay. Earlier, you had mentioned we had been to court in December regarding these assets. We've been to court a number of times over this list of assets, and I put forth great effort to make sure he had possession. So I'm feeling a little bit like this court today's, I don't believe bad faith is the right term. Again, I apologize. I come from an accounting, operations management, and construction arena. I may not use the correct legal terminology. So ultimately, last year at this time, I had a house, I had access to 3 vehicles, I had all my business tools in order, I was getting geared up to remodel our home, and I had parentage of 4 children. Okay, today, while also maintaining my business property. A year later, I am considered homeless. I don't have a vehicle to get to work. I don't have business tools to go to work. And I am in fear of contact of any of my children because my ex-spouses will have me arrested if I contact them. So in a CIR, or any type of business dissolution or CIR, the difference is love and affection and a long-term stable relationship with intention of, in my terms, a mutual retirement plan. I have business relationships with a lot of people. Mr. Bopp is the only person I made a retirement plan with over the last 5 years. So that's the difference in a business agreement versus a CIR, is I loved this guy, and resources were pulled into a long-term retirement portfolio. I started financial services at age 20. It's something I do. I help people build up their homes and their retirement. And I built a retirement with Mr. Bopp, and that looked one direction. Today, our directions have changed. His position has not changed much. He still has his car. He still has the house. He still has all the assets. He has his job, and he has access to his daughter. So here again, we're arguing over property. I built a shed off the back of the property. It's a $40,000 shed. We haven't discussed my either payout or reclamation of said shed. It's on the property. If we assign Mr. Bopp ownership of Parkview, what happens to my investments? Part of our contract last year when I started construction is that he pays me for the job that I did, AKA the hardwood floor remodel. He was supposed to pay me for the job of refinishing the hardwood floors before he began using them. It is my guesstimate after a year that he is using the floors that he has not paid for yet. It's standard contracting agreements. It's something he agreed to. He failed to pay and yet is using the assets. How do I claim ownership of just the hardwood floors? You know? So I am seeking payment over my investment into that property, but I own the floors. I own the paint on the walls. I own all of the elements that went into making that a house. So we can't split the house, you know? So I'm willing to cash out, but until there's a cash out value assigned that I can put onto my balance sheet because I'm in tax season. I have to file taxes. My quote, either CIR and or employer has not paid in 2 years. You know what that does to my balance sheet as a business? I can't get a loan because I can't claim an income because the guy that I've been working for the last 2 years hasn't chose to deposit money into any of my accounts for the work that I've done. I'm stuck until valuation is determined, and I either have a loss of the $100,000 that he said he owed me last June. This issue hasn't changed one bit. In May of last year, he put in a protection order stating, I said he owed me $100,000. He said I was insane. He needed protection from me because I wanted paid out for my job. So the issue is still the same. I've done the math 3 different ways. I've done it CIR, I've done it business, I've done it as an employee. It's a $100,000 difference on my balance sheet. I can't erase that gap. So either I show in court that I just lost $100,000 by trying to leave a relationship, or I get paid or whatever. But in order for me to prove to my investors that I had value the last 2 years and I actually did something with my time, and I can prove that I did something with my time, I can't prove payment for anything that I've done with either of the 2 house remodels that I've done with the respondents. I remodeled 2 homes and I don't have payment for either home that I've remodeled. That's a $100,000 deficit in my income statement. I need to address that. It's tax season. I would like to take care of this money issue. If we want to just settle on the money, we can settle this case. It's not an issue of assets or items. He can have everything from the relationship. I just need the ability to have my investors say, yeah, you're a good investment. We'll go ahead and approve your loan so I can move forward in life. And I need a way to get to work, and I need my business tools to do the job. So I'm happy to buy my own, but I need valuation and the money to do that, to move forward. And that's ultimately all we're disputing is, what do I get paid for remodeling these 2 homes with this guy? We had an agreement on both of them. I did my part. I put in my skill and my labor. He offered assets as part of his consideration for what I did. Now he's trying to rescind his offer of those assets, like the expedition. He gifted that to me in 2018, put me on the insurance in April, and claimed it stolen in May. I don't understand, but I don't want that car. I need a different car though, you know? So I don't want the expedition.
Ask you a quick question.
Yeah.
Yeah, I appreciate your feedback and the information that you're sharing. More specifically, this is a motion related in part to the December 29th, 23 order where the court made a finding of separate property as it relates to the Parkview address, the boathouse, and the property in Exhibit F. So I'm hoping you can address your comments to that issue. Ms. Winkles made an argument that order had been ordered. There is no motion for reconsideration, no appeal of that particular order. And so at this point, the court has made a ruling related to that property. And basically her motion is to, for lack of a better term, kind of rubber stamp that and grant it as a partial summary judgment as it relates to those 3 categories of items: the residence, the boathouse, and the property in Exhibit F. So while the information you're sharing is obviously important, I'm hoping you can focus your comments on the issue that's before the court today, which is should there be an order establishing the real property at Parkview, the boathouse, and the property in Exhibit F as the separate property of Mr. Bob, and then move forward to a separate trial probably, or mediation, what have you, whether there is a committed intimate relationship and if there is to be any type of division of property or what have you. So I'm inclined at this point, because of that prior ruling, without an appeal, without a reconsideration motion, of granting the motion that Ms. Winkles has brought, and then allowing the parties to work on other aspects of the case, whether it be through mediation or through trial, which would include the committed intimate relationship argument and potential separation or division of property and funds and the like. So I'm hoping you can address those issues.
Is it my turn?
Yeah, the question was posed to you.
Okay. So I'm looking at you're referring to the order granting defendant's motion for partial summary judgment. That's the order you're referring to?
Yes, dated December 29th, 2023.
Okay. As I said, I am not trying to separate assets. I am simply attempting to secure my interest in at some point getting paid out for what I've put in. So as far as Parkview Drive go, I have an interest in there. I'm happy to allow him, I believe he has to have a clean title to refinance. And if that's the case, fine, but I do have an interest in that property. How do we mark that? And then the 2000 Expedition, it was my vehicle. I'm happy to have that be his vehicle, but I do need a replacement vehicle because it was mine and I don't have an alternate. The boathouse, I don't have any interest in. I'm happy to release that. So I'm not arguing allowing the order for him to have releasement of title. I'm nervous they won't honor my interest at a later point.
Right, that's what it sounds like is your concern. Your concern is that if the court finalizes this and says the separate property of the residence is Mr. Bob's, then you're concerned about your contribution to the value of that separate property and being reimbursed for any funds or labor expended.
Correct.
Okay. All right. Thank you for answering that question. I appreciate that. Let's, if we could, if Ms. Winkles, do you have any additional items? I think I have a fairly clear idea of what the proper outcome is of today's hearing is.
I have no further argument, Your Honor.
Okay, Ms. Gronitz, I'll give you the last word. Any final comments you'd like to present?
I'm reviewing my notes. Discovery. We're still in the discovery phase. No, I think that we discussed the necessary issues on my list.
Okay. All right, thank you. I appreciate the perspective and input of both parties. I think that the salient issue, well, there's two salient issues. One is that there was a December 29, 2023 ruling, which made a determination of what the separate property involved here is based on the dates. The June 18th or June 2018 is a key date. The April 23, 2023 is a key date, and the court made a ruling based on those key dates. Court didn't make any determinations as far as a committed intimate relationship, didn't make any determinations as to contribution or labor expended or benefits granted. The court just made that determination about those particular items of property. So I'm going to grant the motion brought by Mr. Bopp via Ms. Winkles on the motion for judgment on less than all the claims that was presented. And I'll just double check with Ms. Gronitz. Did you receive the proposed order that Ms. Winkles submitted along with the motion? There's two of them. It looks like one is order on judgment for less than all claims or parties. That's where it basically says that the property, the Parkview Drive, the boathouse, personal property, and Exhibit F, the separate property of Mr. Bob. The other is the final judgment on motion for partial summary judgment. That basically indicates the same. So while it's not subject to division, there's, I think, if there was a properly asserted counterclaim of contribution or enhancement of value or labor not compensated, I think those probably still remain. So any concerns about those proposed orders from Ms. Winkles that she submitted?
I apologize, Your Honor. I don't have those in front of me. and I haven't recently reviewed them. I can't, so I'll have to. I don't have feedback about them because I haven't looked them over, or I don't have them to look.
Sure.
Uh,
Sure. So just looking over them, we looked at them previously. I'm just looking at them again. It basically it reiterates that the Parkview address is separate property, as is the boathouse, as is the personal property in Exhibit F, and that he's entitled to a judgment affirming that property, separate property status. So I think the orders as presented. I'll sign off on both of those. Ms. Winkles, I have a photocopy of those that were submitted as proposed orders. Would you be in a position to send those to me via email, a clean copy, and CC Ms. Gronitz in that?
Absolutely.
Okay, that would be appreciated. Once I receive those, I'll sign off on those. And then the parties will be free to negotiate and mediate or set for trial or what have you. So I
All right.
appreciate the input from the parties. I'll look forward to that email. So
All right.
I think that concludes our hearing for today. We'll be in adjournment.
Thank you, Your Honor.
So the order is set as written, and if I want to make an interjection, I have to do that separate.
Well,
or not that's not the right word, but
yeah. So sometimes what will happen, we'll have a hearing, and the court will make an oral ruling, and a proposed order at that time will not have been submitted. And so then the parties, based on the court's oral ruling, will prepare an order to match what the court orders. We're in a distinct situation here where a proposed order was submitted to all parties, including the court, and ostensibly was reviewed by all parties. And then a court has made a ruling that is basically in conformity with that proposed order. So in my view, that proposed order accurately portrays what the court ordered here today. And so a separate hearing to kind of ratify or affirm that order is not necessary, because I've done that here, in that I've reviewed the proposed order. I feel it's appropriate, and that you, Ms. Gronitz, had received a copy of that order prior to the hearing. And so there's an opportunity to review that, opportunity to be heard on that issue. So from my vantage point, further hearing is not necessary, because I've reviewed that order, and I think it fairly captures what I wanted to say.
So in theory, I shouldn't have to come back to court about this specific list of items again, because it should be done, right? We should be done arguing over this list of items. We can move on to the next subject.
You know, from my vantage point, that the exhibit F that contains different items of property, that's the separate property of Mr. Bob. Where the parties decide to go or what's important to the parties, I'll leave that to each, and I won't make any prospective rulings on that.
Okay.
Good.
Well, it's been a while. We've been over these items a long time, and so if we could bring these to a close, I'm great with that. So.
Okay.
I appreciate your time today, Your Honor.
All right, very good. I appreciate the input from all parties. Thank you.
All right, that brings me to the final matter, Grounitz and Bob matter.
That letter's ready.
Okay, we have Mr. Bob, we have Ms. Winkles, and who else did we have?
This is Mandy Gronitz, Your Honor.
Okay. All right, Ms. Winkles.
Yes, Your Honor. Just a little background. We served our first ROGs in this case on 9/27 of 2023. That meant they were due back on 10/24. We had a CR26I conference held on November 13th. We extended it to 1/17. We received a little bit on December 12th. We received a couple more on January 5th. I did another CR26I on 1/3, extending it to 1/17. Held another conference on 2/12, CR26I, extending it to 3/4, trying to give as many chances as I can. We have received nothing essentially since 1/5. I even gave her access to a Dropbox file so that she could just load them up. I offered to give her a flash drive to put them on. I offered to stay open late. There is no more that I can do. I don't have residential address. I don't have employers. I don't have anything about her mental health history. I have lots of reserved with no proper objection. I am missing about, I believe it's out of all of the interrogatories, I am missing 68% of them, over half. And the ones that I'm missing are the ones that are vital to this case, namely what community assets she's claiming, what community debts she states she has, what her income was during that time, anything about a ring, anything about a committed intimate relationship, essentially every single thing that I have waited, almost, I don't know, 5 more months. So it's been almost 7 months now waiting for this stuff. I can't move it forward to trial. We're done. We submitted all of our discovery, every single answer, and we provided it. We mailed it. We even had, I believe, a courier is going out there with it, even though it's huge. And we submitted it in Dropbox for her. She claimed she couldn't access it anymore. I set up another one. She claimed she had no access to that. I set up another one. At this point, I'm throwing my hands up because I don't think I've ever been quite this nice and friendly and accommodating to anybody in discovery, and I can't do anything. My client's just waiting. This will never go to trial. When we call her, she says she's making a spreadsheet or she's doing something of that nature. She's consolidating it. I don't need what she consolidates. What I need are the actual documents that come from the bank, the retirement, the employer, those things. So I'd ask that you find her, that you compel her, that you assess attorney fees in this case, because that seemed to be the only thing that worked in our other cases, that we set a review for 2 weeks, and that if she doesn't turn it in by then, you strike her pleadings. And I'm hoping that will spur her on to actually get us the documentation that we need. I don't even know what her current employer's address is. I know absolutely nothing that is useful. All the questions she did answer are the ones that are somewhat useful, but they're not useful in me making a spreadsheet of assets and debts so we can finally dissolve whatever relationship they had, be it a CIR or be it friends or be it whatever it was. I can't move it to a trial. It's just going to continue to languish.
All right, Ms. Grounitz,
Yes.
anything you'd like to say?
Good morning. Yes, I do have some things to say. I intended to bring up a lot of issues. However, I have had a chance to overview my breakdown of projects at hand. This case has been agreeably one of the most daunting cases I've ever had to work on. My background is finance, accounting, and contracting. That's where I excel, and this last year has been an attempt to navigate the court system. It is not my professional arena. I've had to do a breakdown of 2024 and determine where my time is most valuable, and that is actually making magic for my clients, the people who want to pay me to show up and are willing to do it without a fight. So I have this case will need professional assistance. And I've delegated the elements of this, distributed the elements of this case to the proper professionals so that Ms. Winkles can get her authenticated reports that she needs and her court compliant reports that she needs to actually carry forward on this case. So as pro se, I'm accustomed to mediation. That isn't going to be an option. I've offered resolve without any damage to Mr. Bob's credit or credibility to date, but I'm faced with financial reporting due. April 15th is tax reporting. This is my employer for the last 2 years. I don't know my income because we haven't had a chance to actually discuss this. So I have to put in my financial statements to the professional financial auditing team, and they can help me determine what that income is, and then I can get that report to Ms. Winkles. And that's been submitted. I am filing an extension for my taxes to buy a 6 months to figure out what it is I'm claiming for an employee wage versus the CAR interest in reimbursement. I haven't disputed any of the assets, and he has all the assets, and he has access to all the assets. He can go get whatever he wants whenever he wants it. His nephew's on the property, he wants something, go get it. Go find it. When I get a chance to tackle that project, I will happily return whatever I have, but what he wants. That's not on my priority list right now because I have clients waiting in queue who want my attention, and I have to offload all the other, anything I can delegate. So the first one's finances because that's the holdup. Second one is legal counsel. My forms have not been court compliant because I have not wanted to counter respond in any damaging way. The reports I am now faced and forced to have to submit because of the position this issue has brought me into will be damaging or could be damaging, and those will be done by professionals so I don't mess it up. That's not my arena. I hand that over to the legal team to address, and they are waiting. I'm awaiting a response on who's going to take lead on this case. I have submitted discovery. It's been used to threaten me and intimidate me back. I have a legal dispute, and it's going to need professional attention. That's in the works. This case keeps coming forward by counsel as a dispute about assets or a dispute about money even. I'm in a position where I claimed an income for 2022 I didn't earn. So
Stop.
I have just 3 more sentences, 3 more statements. Please let me finish.
Stop.
Winkles. This is about family law. This is about my children.
Unless you want to go
right
now and go to jail, stop.
What?
I asked you to stop. I expect you to stop. I've allowed you.
May I have a
All right. I have asked you to stop. When I ask you to stop, I expect you to stop. I get when people are on Zoom that somehow they think that the court rules don't apply. They do. I've allowed you to go on about things unrelated to the motion before this court. This is only about discovery. It's not about settlement. It's not about what he can come and get. It's about none of those things. So I'm done hearing things that are not relevant to what we are here about here today. If you want to say a couple of sentences that relate to what we're here about today, then I'll let you say it, but I'm not going to have you go on and on. Is there anything else in regard to the discovery? Only the discovery.
My discovery is delinquent due to the fact I've dispersed it to professional teams. I'm awaiting their reports to give to Winkles. I'm asking the courts to give the time for the financial team to report back to me what the issue is that Winkles trying to address is the income. She's seeking this information. I am trying to get it to her.
Ms. Winkles?
Yes, I'm not sure what expert she's hired or why. Bank statements don't need an expert. Retirement, you call up a phone number. Employer, you write it down. All of these documents can be given by anybody. And she's had 8 months, 9 months to go get them. I've subpoenaed who I can. And I'll continue to, whenever I find out, oh, she might have worked here, I'll continue to subpoena at great cost to my client. But the fact is, I don't need her expert report. That's the whole point of it, is we get the background documents and we hire our own expert. And then they can decide what is there and what is not. The fact is she's not compliant, and she's going to continually drag her feet. I've had 3 CIRs giving her plenty of time. And why did she hire? Let's just say this person has all of her tax documents and she can't give them to me because that's one of the things I requested. I'm not sure why she can't go on the IRS website and get it. It takes 5 minutes. But aside from that, our first CIR was back in November. And then we had another one in January and another one in February. And by the end of it, it was almost as if her dog ate her homework. Every time there was a different excuse. I couldn't go here. I couldn't get this document. This happened. At this point, I think that it's excuses and excuses. It doesn't make any sense. You can send a child into the bank to get bank statements. So I'd ask that Your Honor find that she has not materially answered these, that assess an attorney fee amount of $1,500. And if we could put it on review, and if she doesn't get them to me in 2 weeks, that her pleadings will be stricken. Because at this point, Mr. Bopp just keeps paying me to show up here and with a new excuse, and she has a new excuse every single time. Thank you.
So I reviewed the files and record and have heard what I've heard today. And based on the files and record, the court does find a 26I. And if you don't know what that is, that's Civil Rule 26I was set and the due date was extended. Additional extensions were made. There was some discovery provided, but none of the missing discovery as of now. Therefore, the court orders the compliance with the request for discovery. It does not require teams of people to put together the documents as indicated by Ms. Winkles. The discovery is to be no later. I'm going to put it on the 23rd, April 23rd. And with full and complete answers, or be subject to sanctions of possibly striking the petitioner's pleading or not allow the petitioner to testify regarding any information contained in the unanswered interrogatories. The court does grant the order of $500 in attorney's fees for the necessity of having to bring today's motion. That is to be paid within 90 days of today's date.
And presentation, can we do that first order on the 23rd?
We can.
Okay, perfect.
All right, that concludes this matter.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes this hearing.
I'm assuming that Ms. Gronitz has no objection. She's here today with a continuance of 2 weeks. She submitted discovery. It was a review. It's Gronitz v. Bopp 23-3-00344-08. I just want the chance to be able to go through that and then contact her. We did receive a bunch of stuff.
So there was also a presentation of order. I don't know. I don't have an order that I see.
You should have an order, but it came a while ago, so we'll go ahead and send another one. It was just the order from the last hearing.
Okay. All right, if you could cover on there and just the explanation of present and that kind of thing would be good.
Absolutely, I will do.
All right, and with that, do we have Ms. Gronitz?
Yes, Your Honor, I'm here.
Anything you wanted to say?
Actually, my financial auditors are requesting 60 days to perform their audit. Ms. Winkles is certainly welcome to the 2 weeks, but I honestly believe that if this doesn't get resolved in the 2 weeks, the auditors are going to need 60 days. We have a $30,000 deficit in accounting. So I would love to work with counsel and find that gap and get this figured out, because I can't give her the income statement she's waiting for until this gets resolved.
And I don't know what I have, so I just asked to set it over and then we can discuss it then.
Okay, so it needs to be set over to May 14.
That's fine.
So I'll go ahead and set it to May 14, and then maybe figure out from there what's done. I'm not sure what the topic has to do with it.
That works for me.
So we'll set it over to the 14th and go from there.
Thank you, Your Honor.
9 a.m.
9 a.m.
Are there any other agreed continuances? Agreed continuances? Not hearing any.
Your Honor, this is Mandy.
Do you have an agreed continuance?
I believe counsel and I are in agreement that we need additional time on this case.
Okay, what case are you talking about?
233-003-4408.
Can you just tell me the names? Obviously, Grounds and, here we go, Grounds and Bob. 23-3-0344-08. Ms. Winkles, are you on here? Oh, yes.
I am, Your Honor. I don't mind setting this over, to be honest with Your Honor. We just got the discovery a couple of days ago. We have gone through it, but I do plan on doing a motion to exclude certain testimony based on your last ruling. In that case, if we could get a 2-week set over, that would work with me. That way we can hear the whole thing at the same time.
All right, Ms. Grounds, are you okay with that? It would be set over to May 28.
Yes, Your Honor.
Okay. All right, so I will go ahead and continue that matter over to May 28. And that will be at 9 a.m.
Thank you, Your Honor.
Okay. So let's go back to Grounds and Bob matter.
Right. Can you hear me, Your Honor?
Okay, thank you.
Could you let me in on the phone so I have better audio, please? 6829.
I hear you just fine.
I can't. Okay.
All right, Ms. Winkles, go ahead.
Yes, Your Honor. We're here. If Your Honor remembers, we've been here multiple times on discovery issues, multiple times. We've had essentially at the last hearing, Your Honor stated that if everything wasn't turned in by the 14th, that would be it, that Your Honor would not allow any more evidence or any testimony at trial about those missing items. We submitted exactly what was missing. We did receive minor documents, but 90% of what we requested is still outstanding. Ms. Granas keeps saying she's going to get us more, she's going to get us more. Your Honor put a drop dead date. That has not been met. I'm asking because of the fact that there is so much missing and only very little has been provided. I'd ask Your Honor for an order today that states that anything that wasn't given before that drop dead date of the 14th cannot be brought up in testimony, and I will file today a motion to actually exclude this specific evidence that we're talking about, so we don't have to waste the court's time today going through each individual item. But you'll see that February 2nd letter that we attached, 90% of that is still missing. So I just asked for an order that states that Ms. Gronitz cannot provide any further documentation or testimony on anything that was not given prior to the 14th.
Ms. Gronitz?
Oh, excuse me, Your Honor. When I reviewed counsel's submission, I believe she submitted an interrogatory packet of 33 pages. She has since that time received other interrogatory packages up in the 100 and some pages. She has received already all of the evidence necessary for this case that she's seen everything that I have to present on this case. What we're missing is information from her side. I'm missing her information.
Hey, that's not what's before me today at all.
Well, if what is before you an issue of whether or not there's additional evidence to be added, the issue I'm having is with counsel's own submissions not matching the problem. So she's arguing or will be arguing her own submissions. So she doesn't really need my information to argue against herself, because the information she submitted to court and the information she submitted to me doesn't match the financial statements that are going under audit. So if the audit doesn't match her court reports, then we have a different issue at hand there. So she's not waiting on information to me to match her own reports to the statements. That's unfortunately the next step. I've had my information audited. I'm going to have to request an IRS audit on Mr. Bob's books because we can't come to an agreement on what's been paid by Mr. Bob or not. And that's where the holdup is. I'm filing a domestic. This is a CIR. This is about property and assets. And I've already relinquished my interest in the assets, but I'm still looking to recoup my income for my value on those assets. And that value can't be determined when we have a conflicting civil claim, wage claim. And both of those issues are not matching the statements, and I can't get counsel to agree on values for either one. So they're contingent upon each other. I have two cases contingent upon each other, and I need a third party to come in and audit the information because the information that's presented to court doesn't match the statements. I don't know where else to go from there. I've made a request for the contract of the parties that's in Mr. Bob's possession, or he can retain it via email. Just has to email Daryl Adams, get the contract from November 21st, and provide proof of payment for the wage, the 1099s that he put into the IRS. And he can match his IRS submissions to proof of payments. That gives me a starting point on the civil claim, and then the balance remaining goes on this domestic claim. So that's where I stand. I can't give her any more information because I have no more information to use until this audit takes place. And
Yes, this is just a really roundabout way of saying I'm not going to give it to you. And the fact is that I'm not asking for her to do any work or audit. I'm asking for bank statements. I'm asking for proof of agreements between the parties in writing. I'm asking for any contracts that were jointly signed by the parties. I'm asking for any bank statements or life insurance policies. I'm asking for things, tangible things that I can put my hands on, documents, photographs, things like that. I'm not asking for Ms. Gronitz to go through anything. She knows that. We've been here 6 or 7 times in this case alone and 6 or 7 times in the last case. I'm asking for the same items. They're not forthcoming. I can't set a trial unless I know what she's going to present. She refuses to give it to us. She keeps saying, you're waiting for my auditor. Well, this case has been in play and these have been requested since September. I'm not sure why she can't have had that done, but I don't need her to audit it. I need the documents and then we'll have our expert do it and her expert can do it and that's great. She hasn't even disclosed an expert, so I don't know any of this. I'd ask that essentially anything that wasn't given prior to the 14th be excluded, and acknowledging that I will be filing a motion to exclude specific evidence because it's too long to go through today. And I will give Your Honor a giant packet, unfortunately, of all the stuff that has been provided. Very little of it is useful. Most of it is like things from high school that she had, things about her mother, things that her children drew. None of that I need. I need very specific items. Ms. Gronitz knows this. If she's smart enough to handle most of this and to do audits, she's smart enough to answer the interrogatories and provide the documents that I've requested. So I'd ask Your Honor to exclude her testimony and any further document submissions from her.
Ms. Gronitz, you have continually said that you can't provide what has been requested because you need to audit. You need an audit. You need an audit. That is not what this is about. This is about turning over hard documents that you have in your possession or control, and that has not occurred. You continue on this route of, well, I need to do an audit. No, you do not. You need to have turned over the documents as requested. So with that, I will grant your requested relief, Ms. Winkles. Get me an order and I'll sign off on it.
All right, thank you.
Is
Your
there
Honor.
an email agreement on this case? But I believe that might be our gap in information, Your Honor, because I've emailed this information. She has 1,200 documents in her possession. Per zip file drive, I have 40 requests for production folders she's been sent.
I don't know what to tell you at this point. Ms. Winkles, an officer of the court, is saying that she's not received it. So if you emailed it, then you're going to have to file proof of that to Ms. Winkles. But that's it for today.
Thank you, Your Honor.
They had a hearing on June 5th to set the date for their trial. The date was set for the week of October 7th.
All right, number 7 and 8, 23-3-00344-08 Bronitz and Bob matter.
That matter's ready, Your Honor, and we've received no reply to our new motion, and I believe the order is appropriate given all the other motions to compel.
Did you send over, and we do have Mr. Bob present, Ms. Winkles, did you send over orders for me?
Yes, Your Honor, we filed the proposed with the cover sheet and we sent over the originals for Your Honor's signature. And that was a couple of weeks ago, though. I would have been, we've had those done for a while, so they might be floating around. We can send you another one today. I can have my legal assistant send that this morning. There's been quite a lot of things that I think it's because of training, is what I've been told. Quite a lot of things haven't quite made it into Odyssey, but that they have them in the clerk's office. But I'm not sure if this might have been one of them. It was a couple of weeks ago, like I stated.
Yeah. I don't have anything, and the clerk seems to be indicating she doesn't have anything.
Okay, we'll have another copy sent over to the court and we'll file another proposed today. Ms. Gronitz did receive copies of that proposed as well, because they were done at the same time as the motion hearing was actually set.
Okay. So I need some clarification, Ms. Winkles. I have on number 7, it says motion hearing. Number 8 says motion hearing to exclude evidence produced beyond discovery deadline and order to show cause.
Yes, so the order to show, the order to show cause is, I'm not sure where that came from, but what it was is, this is our fourth compel hearing that we had. So that was the compel was just a review set over. We still have received no information. The motion to exclude evidence, if Your Honor remembers at the last hearing, Your Honor stated that you were going to exclude evidence if it wasn't turned in, but because it was such a huge amount of evidence, I wanted there to be a separate motion so I could actually provide Your Honor, and this is the sheer amount of information that I submitted to the court was quite a lot. I wanted to supply that information prior to and give Ms. Gronitz the ability to obviously provide that information should she have it. It's listed out every single thing that's missing. It's like a 5-page order because of that. So those are the only 2 things. It would just be the review of the order compelling, the 4th one, and then a separate order excluding specific evidence, so that there's no question about what still had not been provided.
Okay, and I just want to double check, Ms. Gronitz.
Yes, Your Honor.
Okay, so if you have video, if you could go ahead and turn the video on, please.
I don't have video capabilities. I apologize.
Okay. All right. So with that, Ms. Gronitz, at this point, the court doesn't feel like it has any choice but to grant the request of Ms. Winkles based on the limited information, plus you didn't do a reply, so I can't really hear any argument either. So that's where we're at this point. Okay.
We have court in October. I'm not sure why we're coming to address this again. Ms. Winkles understands that this is being modified due to the auditors. Last time we attended courts requested I had the auditors get involved and submit a report to court that is tied to this case. And that's what's been taking place. So why is, there was a lot of information delivered to Winkles. I'm just catching up to speed on the 1,200 pages that she sent me in regards to this case, and recognizing the deficiencies in my report to what she's claiming she's received. So there's a trend, I need to go through and audit my report to match her requests. But up until receiving this motion, I believed she had far more information than she reveals to court to have received, specifically the descriptions of the evidence. So those were separately described, and it looks like they need to be incorporated into the actual report. And that report also needs to get submitted to court, but I've been operating out of state, and I have to secure a courier to actually get that report submitted into the court system, which I've done, and they're available next week. So I'm not exactly sure what she's requesting on this, but I'm requesting that this entire motion be stricken, given it's completely out of compliance with the discovery protocol under the schedule that we previously set. I've been telling her exactly what's been going on in discovery, and she hits me with this 4 months early. Trial's not till October. Now, there is information that isn't going to get added to this case, and I'm going to be withdrawing or modifying the financial documents that are applied to this case. And I would like the opportunity to change those valuations without recourse, because this case has now been broken up into several smaller cases. So we're only dealing with the asset portfolio valuation difference of the parties in this case, a list of personal property and who purchased those items. I haven't received any information of purchases or payments made by defendant. I do have his financial statement, so I can go ahead and address my financial issues. My financial issues are the reason that we're in court for me. I need my financial issues addressed. I've been issued 1099s.
Your Honor, I'm going to object. This is not properly before the court.
Ms. Granitz?
It is extremely
Ms.
relevant.
Granitz, stop.
This
Ms.
is about
Granitz, stop. So first off, you didn't do a written reply, which is what's required. You didn't do it. Secondly, I don't know what you're talking about as far as the requiring an auditor's report. Maybe Ms. Winkles knows what you're talking about, but I don't. So I don't know what you're talking about there, but there are rules that need to be followed and they have not been followed. So whether or not your trial isn't until October is, if you haven't followed the discovery rules, which is what we're here for, then that's on you. So with that, Ms. Winkles, anything?
Just briefly, I'm not sure what this auditor's thing is. That was never required by the court. I actually submitted everything she submitted to us. I did that. That's why I renoted this just in case this argument was going to come up, to show that the deficiencies are there. I've written out the deficiencies. I've been very, very clear. I listed them in numbered format on the motion and the order, so Ms. Granitz would have time in that 21 days to respond and give me them. She did not do that, so I'd ask that the order be entered today.
So the court has seen this case over and over again, and the failure of Ms. Granitz to provide what is required, not to create. Discovery is not about creating records. It's about providing the records that you have. And that doesn't seem to be understood. So with that, Ms. Winkles, I will sign off on your order.
And we'll have that submitted to Your Honor this afternoon. Thank you.
This matter's done for today.
On October 1st, they had their readiness hearing, and on October 11th, they started their trial. The trial was continued for a second day to October 31st. Judge Evans issued a ruling denying any committed intimate relationship or any contractual claims, so I guess he didn't believe Mr. Bopp was her employer either. They had a hearing on March 31st, 2025, where Judge Evans signed the final orders and a judgment. And speaking of that judgment, Mandy was ordered to pay Mr. Bopp nearly $30,000 in what I assume are attorney's fees. In April, Mandy tried to file documents, and she was denied because the case is over. Attorney Winkles also withdrew in April, again because the case is over. Despite that, in June, Mandy tried to file more documents and was denied again. That was the last entry for the committed intimate relationship case. Remember how I mentioned there was a third case for a protection order? They don't stream those, but I have the screenshots. Mr. Bopp was the one who motioned for a protection order. It took them 4 hearings, but Mr. Bopp was granted a protective order. I think we've all figured out why by this point. So the case should have been done, right? But Mandy started filing motions and documents, demanding advanced lawyer fees and costs, just like she tried in the other cases. Not only was her motion denied, but Mr. Bopp countered her motion with a motion of his own to restrict abusive litigation. After several hearings, his motion was granted. Not only was the motion granted, but he was also awarded a judgment of $4,395 in attorney's fees for having to deal with all her filings. In August of 2024, Mr. Bopp motioned the court to have the restraining order extended, and although it took them 6 hearings to get proper service, in the end his extension was granted. That was the last time they were in court for the protection order case. In the end, Mandy has 5 judgments against her in 3 different cases with Mr. Bopp, totaling a whopping $45,328, although none of them show as being paid. I'm not sure she has the ability to pay a judgment, but she may have assets that Mr. Bopp can go after. She did mention owning property. I think the biggest irony here is that she's the one who filed the CIR claim, which is the case with the largest judgment against her at nearly $30,000. If she hadn't been so determined to get what he owed her, or been so difficult about the discovery process, it never would have been that bad. She did all of this to herself by refusing to listen or respond appropriately, and all she's done is cost herself thousands of dollars, and she's lost access to her children. I really hope she looks for some treatment or therapy, because it's obvious she desperately needs it. Thank you for watching.